Unit 7 Unit 8. Forms of legal entities. Learning outcomes. Students will be able to identify different forms of business entities, organizations, explains features, merits and limitations of different forms of business entities, organizations, distinguish between various forms of business entities, organizations, discuss the factors determining choice of an appropriate form of entity, organization. Introduction. If one is planning to start a business or is interested in expanding an existing one, it is important to understand the different forms of organizations. Choosing the right legal structure is aligned to the goals of the entity and the local and central laws where it desires to establish its base. In India, there are three major types of business frameworks: sole proprietorship, partnership and company, public or private. Over the years, hybrid and newer versions of the same have arisen, such as limited liability partnerships. Each form of business has its own pros and cons. Objective of law: regulation of legal entities. The purpose of law regulation of forms of legal entities is to provide a framework for the creation, management, and dissolution of different types of organizations, such as corporations, partnerships, and sole proprietorships. These regulations aim to protect the rights and interests of stakeholders, including shareholders, employees, customers, and creditors, and to ensure the fair and transparent functioning of these entities within the legal and economic system. Additionally, law regulations of legal entities may also promote competition, prevent fraud and misconduct, and provide a clear understanding of responsibilities and liabilities. 2. Types of legal entities in India. 1. Sole proprietorship. Sole proprietorship is a popular form of business organization and is the most suitable form for small businesses, especially in their initial years of operation. Sole proprietorship refers to a form of business organization which is owned, managed and controlled by an individual who is the recipient of all profits and bearer of all risks. The word sole implies only, and proprietor refers to owner. Hence, a sole proprietor is the one who is the only owner of a business. It is the easiest type of business to establish or take apart, due to a lack of government regulation. Chapter 4b, Textbook of Legal Studies 12-2023-2024. www.cbcacademic. NIC. In. Unit I. Unit 2. Unit 3. UNITIV. Unit V. 102. Unit V. Unit 7. Unit 8. As such, these types of businesses are very popular among sole owners of businesses, individual self-contractors, and consultants. Most small businesses start as sole proprietorships and either stay that way or expand and transition to a limited liability entity or corporation. This form of business is particularly common in areas of personalized services such as beauty parlors, hair salons, and small-scale activities like running a retail shop in a locality. Salient features of a sole proprietorship are as follows. No. Feature details. 1. No separate entity, no difference in the eyes of the law between the owner and business. 2. Formation A. No specific law. B. Business is owned by single person. C. No formal registration. 3. No. Of members, minimum 1. Maximum 1. 4. Liability A. Unlimited liability. B. Owner is responsible for all losses, debts and liabilities. 5. Profit. If the business is successful, the owner enjoys all the profits. 6. Control and decision making. The right to run the business and make all decisions lies absolutely with the sole proprietor. 7. Limited life of the business. As the business is owned and controlled by one person, death, insanity, imprisonment, physical, mental incapacity or bankruptcy will have a direct impact on the business and lead to its closure. 8. Confidentiality. Sole decision-making authority enables the proprietor to keep all information related to business operations confidential and maintain secrecy. Advantages and disadvantages of sole proprietorship. There are several benefits as well as limitations of running a sole proprietorship. Some of those points are discussed below. Advantages: quick decision making, confidentiality of information, owner receives all the profits, owner makes all decisions and is in complete control of the company, easiest and least expensive form of ownership to organize, easier formation and closure, the business does not pay separate taxes. All income passes directly to the owner and is taxed at the owner's personal tax rate. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In 103. Unit I. Unit 2. Unit 3 UNITIV. Unit V. Unit 7. Unit 8. Disadvantages. Unlimited liability if anything happens in the business, limited in raising funds, no separate legal status, limited funds and resources, limited skills and managerial ability of the proprietor. 2. Partnership. The Indian Partnership Act, 1932 defines partnership as the relation between persons who have agreed to share the profit of the business carried on by all or any one of them acting for all. Persons who have entered into partnership with one another are called individually partners, and collectively a firm, and the name under which their business is carried on is called the firm name. The inherent disadvantage of the sole proprietorship in financing and managing an expanding business paved the way for partnership as a viable option. Partnership serves as an answer to the needs of greater capital investment, varied skills, and sharing of risks. A successful partnership can help a business thrive by allowing the partners to pool their labor and resources. But there is also an additional risk in joining a partnership. In addition to sharing profits, the partners may also assume responsibility for any losses or debts from the other partners. Strategic partnerships are formed when two or more businesses or individuals come together to achieve mutual goals and enhance their respective brands. By co-branding and combining resources, strategic partnerships can provide benefits such as increased brand awareness, improved brand trust, and access to new markets and customers. Some well-known examples of successful strategic partnerships include Spotify and Google, Sherwin-Williams and Pottery Barn, and McDonald's and Coca-Cola. These partnerships have helped both companies to grow and succeed in their respective markets. In the case of law firms and medical practice, often individuals who are experts in their field join together to form partnerships with other experts to enhance knowledge, greater reach, joining of several subspecializations, more trustworthiness, and for all-round solutions to their clients. Salient features of a partnership are as follows. No. Feature details. 1. No separate entity. A partnership firm has no separate legal existence of its own, i.e., the partnership firm and the partners are one and the same in the eyes of law. 2. Formation. There are two types of partnership firms, registered and unregistered. It is not compulsory to register a partnership firm. B. Registration by the Registrar of Firms under the Indian Partnership Act, 1932. C. In order to enter into partnership, a clear agreement with respect to the terms, conditions, and all aspects concerning the partners is essential so that there is no misunderstanding later among the partners. This written agreement is called a partnership deed. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In. Unit I. Unit 2. Unit 3. UNITIV. Unit V. 104. Unit V. Unit 7. Unit 8. 3. No. Of partners minimum 2. Maximum 50. 4. Liability. Unlimited liability. B. Partners are jointly and severally liable for the liabilities of the firm. 5. Profit. Partners share profits in a mutually agreed ratio. 6. Control and decision making. Partners enjoy shared responsibility amongst each other. This may sometimes raise conflicts in decision making. 7. Dissolution. Partnership firm can be dissolved by way of compulsory dissolution or by way of agreement. 8. Funds. Capital is contributed by the partners. This makes it possible to use larger amounts of funds. Partnership advantages. Easy to establish, with the exception of developing a partnership agreement, separate legal status to give liability protection, partners may have complementary skills, startup cost is low, more capital is available for business. Partnership disadvantages. Partners are jointly and individually liable for the actions of the other partners. Profits must be shared with the partners. Divided decision making. Business can suffer if the detailed partnership agreement is not in place. 3. Limited liability partnership. A limited liability partnership, LLP, is a body corporate formed and incorporated under the Limited Liability Partnership Act, 2008. A limited liability partnership, LLP, is a type of business that combines the benefits of limited liability with the flexibility of a partnership. It allows members to organize their internal structure based on an agreement. This type of business is suitable for entrepreneurs, professionals, and enterprises that provide services or engage in scientific and technical disciplines. It is also a good option for small enterprises and for investment by venture capital due to its flexible structure and operation. Textbook of Legal Studies 12-2023-2024. www.cbckdemic. NIC. In 105. Unit I. Unit 2. Unit 3 UNITIV UNITV. Unit V Unit 7 Unit 8. The salient features of a limited liability partnership are as follows. S. No. Feature details. 1. Separate entity. A LLP is a separate legal entity from that of its partners. B. It shall have perpetual succession. C. Any change in the partners shall not affect the existence, rights or liabilities of the LLP. 2. Formation. A written agreement known as a limited liability partnership agreement is entered into between the partners of the LLP or between the LLP and its partners, which determines the mutual rights and obligations. 3. No. Of partners minimum to maximum, no limit. 4. Liability. A liability of the partners is limited to their agreed contribution in the LLP. B. No partner is liable on account of the independent or unauthorized actions of other partners. 5. Capital. An LLP can be started with no minimum amount of capital contribution. 6. Less registration cost. The cost of registration is lesser as compared to a private limited company or public limited company. Advantages of an LLP. There are several advantages to operating as a limited liability partnership, LLP. The terms and conditions of an LLP are based on a mutually agreed LLP agreement, providing greater flexibility and ease. The cost of registering an LLP is lower than incorporating a public or private limited company. Partners are only liable up to their agreed contribution, and there is no joint liability created by the actions of another partner. The registration process is simpler compared to that of a company. Remuneration, voting rights, and other aspects are clear and defined in the LLP agreement, with no restrictions on partner remuneration as long as it is authorized by the agreement. The LLP can sue and be sued in its own name, protecting partners from being personally sued for the LLP's debts. There is greater flexibility for becoming a partner, leaving the LLP, or transferring interest in the LLP. Partners are free to enter into any contract, and the LLP enjoys higher credit worthiness compared to a partnership, although lower than a company. There is no mandatory requirement for auditing accounts, and the LLP can raise funds from private equity investors and financial institutions. Textbook of Legal Studies 12-2023-2024. www.cbckdemic. NIC. In. Unit I. Unit 2. Unit 3. UNITIV. Unit V. 106. Unit V Unit 7 Unit 8. Disadvantages of LLP. There are some disadvantages to operating as an LLP. Actions taken by one partner without the consent of others can bind the LLP. In some cases, partners may also be personally liable for the LLP's debts. The winding up process, as outlined in the Limited Liability Partnership, Winding Up and Dissolution Rules, 2012, can be lengthy and costly. LLPs have lower credit worthiness compared to companies. LLPs are required to file annual statements of accounts and solvency, as well as an annual return with the Registrar of Companies, which is not a requirement for partnerships. 4. Private Limited Company. A private limited company is a popular business structure amongst growing businesses and companies. A private limited company is a separate legal entity registered under the Companies Act, 2013. It is a type of business entity that is owned by a small group of individuals and registered for specific business objectives. It is a popular choice for startups and businesses with high growth aspirations due to the limited liability protection it offers to shareholders and the flexibility it provides in terms of ownership and management structure. The salient features of a private limited company are as follows. No. Feature details. 1. Separate entity. A private limited company is said to be a separate legal entity. Therefore, the company can sue and can also be sued under its name. 2. Formation. The private limited company is to be registered under the Companies Act, 2013. B. Incorporated documents such as Memorandum of Association and Articles of Association are required. 3. No. Of members minimum 2. Maximum 200. 4. Liability. The liability of each member or shareholder is limited. The personal, individual assets of the shareholders are not at risk. 5. Capital. It must have a minimum paid up capital of such amount which may be prescribed from time to time. 6. Borrowing capacity. A private limited company enjoys the privileges of borrowing more funds. 7. Easy exit. Private limited companies can be sold or transferred, either partially or in full, to another individual or entity without any disruption to the current business. 8. Perpetual succession. The company keeps on existing in the eyes of law even in the case of death, insolvency, the bankruptcy of any of its members. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In 107. Unit I. Unit 2. Unit 3 UNITIV UNITV. Unit V. Unit 7 Unit 8. Examples of popular private limited companies: Flipkart, Freecharge, Cafe Coffee Day. 5. Public limited company. As per Section 271 of the Companies Act, 2013, a public company means a company which is not a private company. A public limited company is recognized as a separate entity from its owners and has the ability to enter into agreements in its own name. It operates independently from its owners and has its own set of rules, obligations, regulations, and legal rights. The owners run the company but have limited liability for its debts and obligations. This legal separation provides a higher level of protection to the owners and makes it easier for the company to raise capital through the sale of shares to the public. The owners of a public limited company are referred to as shareholders or stakeholders, and the ownership of the company is divided into units known as shares or equity shares. These units of ownership can be held by multiple individuals or corporations, making it easier for the company to raise capital by selling shares to the public. The shareholders have a right to participate in the decision-making process of the company and receive dividends from the company's profits. The salient features of a public limited are for the company to raise capital by selling shares to the public. Why but have limited liability for its debts and obligations. This legal separation provides a higher level of protection to the owners and makes it easier for the company to raise capital through the sale of shares to the public. The owners of a public limited company are referred to as shareholders or stakeholders, and the ownership of the company is divided into units known as shares or equity shares. These units of ownership can be held by multiple individuals or corporations, making it easier for the company to raise capital by selling shares to the public. The shareholders have a right to participate in the decision-making process of the company and receive dividends from the company's profits. The salient features of a public limited company are as follows. No. Participate in the decision-making process of the company and receive dividends from the company's profits. The salient features of a public limited company are as follows. S. No. Feature details. 1. Separate entity. Public limited company is a separate legal entity registered under the Companies Act, 2013. 2. Formation. The public limited company is to be registered under the Companies Act, 2013. B. Incorporated documents such as Memorandum of Association and Articles of Association are required. C. Public limited companies could be listed in the stock market or could be unlisted. 3. No. Of members minimum 7. Maximum, no limit. 4. Limited liability. The liability of the shareholders is limited to their stake only. 5. Capital. A public limited company is required to have a minimum paid up capital of an amount is prescribed under the Act. B. Public limited company can relish an increased ability to raise capital through the stock market by issuing debentures and bonds from the public. 6. Perpetual succession. The lifespan of the public limited company is not affected by the death of any member or shareholder. 7. Strict regulation. A public limited company is strictly regulated and is required to publish its true financial health to its shareholders. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In. Unit I. Unit 2. Unit 3. UNITIV. Unit V. 108. Unit V. Unit 7. Unit 8. 8. Transparency. All information relating to a public limited company is available to the public, including detailed financial statements and structure of the management. 9. Transferability of shares. The shareholders are free to buy or sell, trade shares to anyone through the stock market if the company is listed and through dealers and other platforms if the company is unlisted. Popular public limited companies in India: Indian Oil Corporation Limited, Bharat Petroleum Corporation Limited, State Bank of India. In comparison to sole proprietorship and partnership forms of organizations, a company has larger financial resources. Further, capital can be attracted from public as well as through loans from banks and financial institutions. Thus, there is larger scope of expansion. Difference between public and private company. Basis: public company, private company. Members minimum 7. Maximum, unlimited. Minimum 2. Maximum 200. Transfer of shares: no restriction. Restriction on transfer. Invitation to public to subscribe to shares. Can invite the public to subscribe to its shares. Cannot invite the public to subscribe to its securities. 6. One-person company, OPC. As per Section 262 of the Companies Act 2013, one-person company means a company that has only one person as a member. This is a recent invention to facilitate entrepreneurs to own and manage companies alone. The salient features of a one-person company are as follows. S. No. Feature details. 1. Separate entity. The OPC receives a separate legal entity status from the member. B. The separate legal entity of the OPC gives protection to the single individual who has incorporated it. 2. Liability. The liability of the member is limited to his/her shares, and he/she is not personally liable for the loss of the company. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In 109. Unit I. Unit 2. Unit 3. UNITIV. UNITV. Unit V. Unit 7. Unit 8. 3. Formation. Incorporated by a single person. B. Incorporated as a private company under the Companies Act, 2013. C. Compliance requirements are lesser than that of a private company. D. An individual can form a company with one single member and one director. The director and member can be the same person. 4. No. Of members. Minimum 1, maximum 1. 5. Easy to obtain funds. Since OPC is a private company, it is easy to go for fundraising through venture capitals, angel investors, incubators, etc. 6. Perpetual succession. The OPC has the feature of perpetual succession even when there is only one member. While incorporating the OPC, the single member needs to appoint a nominee. Upon the member's death, the nominee will run the company in the member's place. 7. No minimum paid up share capital. Companies Act, 2013 has not prescribed any amount as minimum paid up capital for OPCs. A sole proprietorship form of business might seem very similar to one-person companies because they both involve a single person owning the business, but there actually exist some differences between them. The main difference between the two is the nature of the liabilities they carry. Since an OPC is a separate legal entity distinguished from its promoter, it has its own assets and liabilities. The promoter is not personally liable to repay the debts of the company. On the other hand, sole proprietorships and their proprietors are the same persons. So, the law allows attachment and sale of promoters' own assets in case of non-fulfillment of the business liabilities. 3. Comparative evaluation of some forms of business entities. Basis of comparison. Sole proprietorship, partnership, company formation, minimum legal formalities. Easy formation. Registration is optional, easy formation. Registration compulsory. Lengthy and expensive formation process. Members only one owner, minimum 2. Maximum 50. Minimum. Private 2. Public 7. Maximum. Private 200. Public, unlimited. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In. Unit I. Unit 2. Unit 3. UNITIV. Unit V. 110. Unit V. Unit 7. Unit 8. Capital contribution. Limited finance funds can be raised. Contributed by partners. Large financial resources. Liability unlimited, unlimited and joint limited. Control and management. Owner takes all decisions. Quick decision making. Partners take decisions. Consent of all partners is needed. Separation between ownership and management. Continuity unstable. Business and owner regarded as one. More status but affected by status of partners. Stable because of separate legal status. IV. Conclusion. A legal entity refers to any business or organization that has legally recognized rights and obligations, such as the obligation to file taxes. These entities have the capacity to enter into agreements as either a vendor or supplier, and can initiate or be a party to lawsuits in a court of law. The choice of business structure has a major impact on taxes, funding, required paperwork, and personal responsibility. It's crucial to make this decision before registering a business. Exercises. Based on your understanding, answer the following questions. 1. State the differences between a private limited company and a public limited company. 2. Ajay and Neelam decide to contribute Rs. 10,000 and Rs. 20,000 respectively in order to start a partnership firm selling saris. Since they are good friends, they forego registering the partnership and have only a verbal agreement to share profit and losses. In the first year itself, due to COVID, the firm suffered a loss of Rs. 30,000. Now Ajay insists that the losses should be borne in the same ratio as the initial contribution, i.e., he should bear 10,000 rupees of loss and Neelam should bear Rs. 20,000 of loss. Whereas Neelam wants them to bear the losses equally. In this regard, discuss the nature and essential characteristics of partnership firms, types of partnership firms, and why it is important to have a written agreement or partnership deed between partners. 3. The people of a village in India make a special kind of silk dress. Due to social media's influence, the dress has become immensely popular in India and abroad, and designers are willing to pay crores of rupees for bulk orders. Since it is not possible for the individual weavers to handle such large orders, they sought the help of a benevolent lawyer who belonged to their village. They want to form a legal entity to enter into the supply business formally. They are also aware that if they come together, their bargaining power will increase. They are ready to contribute a fixed amount initially. They also realize that they will require to raise capital from investors in order to fulfill their orders. A few of them have adult educated children who are ready to take up the management of the formal entity. There are about 100 weavers who are willing to come together to form the entity. If you are the lawyer they have approached, suggest which will be the best form of legal entity in this case and why. 4. Raj owns a small provision store. He has borrowed a sum of 70,000 rupees from a moneylender to run his business. Raj dies from COVID before returning the amount. Can the moneylender recover his money? Discuss the liabilities of a sole proprietorship firm and its advantages and Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In 111. Unit I. Unit 2. Unit 3 UNITIV. Unit V. Unit 7 Unit 8. Disadvantages. 5. A giant cola company wants to enter the Indian market. They have a huge market in foreign countries. They also want to raise more funds from the public in India. What is the best way for them to enter the markets? What legal entity should they form to be able to do business in India? Discuss the characteristics of such an entity. Activity-based question. 1. Two friends Tanmay and Pinaki decide to start a business. They have 5,000 rupees each to contribute towards the business. They want to share the profits equally. But in case of a loss Tanmay has agreed to bear 60% of the loss. They have decided to conduct the business using Tanmay's commercial property at 1, Mango Lane, Bangalore 2, as the registered address. Also, if they ever wind up the business, the liabilities and assets existing at that point will be shared equally between the partners. Draft a partnership agreement between the two partners. Add any other details you think are necessary for the conduct of the business. 2. Identify one partnership firm, one proprietorship firm, one private limited company, and one limited liability partnership functioning in your city, town, country. Discuss how their products, services are used by you and what is the extent of liabilities of their stakeholders spending on their form of business. OR. Research, identify and discuss the legal forms of the following entities: A. Coca-Cola, India. B. KFC, India. C. An e-commerce giant that started as a sole proprietorship firm in India. D. A law firm that is a partnership. A. The first limited liability partnership firm of India. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In. Unit I. Unit 2. Unit 3. UNITIV. Unit V. 112. Unit V. Unit 7 Unit 8. Criminal Laws in India. Learning outcomes. Students will be able to define the term crime. Identify and explain the objectives of criminal law, explain the fundamental elements of crime, distinguish between intention and motive, identify and analyze the various stages of crime, distinguish between admission and confession, analyze and explain the various forms of confession, evaluate the relevance of dying declaration. I. What do we understand by crime? The term crime denotes an unlawful act, and this unlawful act is punishable by a state. Crime as a concept is so broad that there is no single, universally accepted definition to it. But, for the sake of convenience, several countries provide statutory definitions of various kinds of unlawful activities, which can be identified as crimes. A common principle about criminal law is that, unless an activity is prohibited by law, it does not qualify as a crime. Incidents of crime hurt not only the individual, but also the state. Therefore, such acts are forbidden and punishable by law. The body of laws which deal with imposing punishments on crimes is known as criminal law. 2. Objectives of criminal law. With the change in the social structure, society has witnessed various punishment theories and the radical changes that they have undergone from the traditional to the modern level and the crucial problems relating to them. Kenny wrote, "It cannot be said that the theories of criminal punishment current amongst our judges and legislators have assumed either a coherent or even a stable form. Malinowski believes all the legally effective institutions are means of cutting short an illegal or intolerable state of affairs, of restoring the equilibrium in the social life, and of giving the vent to the feelings of oppression and injustice felt by the individuals. 5 objectives are widely accepted for enforcement of the criminal law by punishments: retribution, deterrence, incapacitation, rehabilitation, and restoration. These objectives vary across jurisdictions. Retribution: this theory basically deals with righting of balance. If a criminal has done a wrong towards a person or property, he needs to be given a penalty in a manner which balances out the wrong done. For example, if a person has committed murder, he can be delivered capital punishment to balance out the suffering caused to the victim and his or her family. Deterrence. Deterrence serves as a major tool in maintaining the general law and order in The. Chapter 4, C. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In 113. Unit I. Unit 2. Unit 3 UNITIV. Unit V. Unit 7. Unit 8. Society. Especially from the perspective of crime. Criminal acts are penalized so as to deter individuals from repeating it or even entering into it in the first place. Incapacitation. The objective of this theory is to segregate the criminals from the rest of the society. For the crimes committed, they suffer a kind of banishment by staying in prisons, and in some cases, they are also subject to capital punishment. Rehabilitation aims at transforming an offender into a valuable member of society. Its primary goal is to prevent further offense by convincing the offender that their conduct was wrong. Restoration. This is a victim-oriented theory of punishment. The goal is to repair, through state authority, any injury inflicted upon the victim by the offender. For example, one who embezzles will be required to repay the amount improperly acquired. Restoration is commonly combined with other main goals of criminal justice and is closely related to concepts in the civil law, i.e., returning the victim to his or her original position before the injury. Ignorantia juris non excusat. If a wrongdoer says that he was ignorant of the consequences of the act done by him, he would not be excused. Because everybody is supposed to know the law of the land, which is guided by the maxim, ignorantia juris non excusat, means ignorance of law is no excuse. It is a Latin maxim meaning ignorance of law or lack of knowledge or mistake of law about legal requirement is not an excuse, and hence liability arises in such cases. 3. Criminal laws in India are broadly covered by the following legislations. 1. Indian Penal Code, 1860. 2. Criminal Procedure Code 1973. 3. Indian Evidence Act, 1872. 1. Indian Penal Code, 1860. 1.1 Fundamental elements of a crime. A. Mens rea or guilty intention. B. Actus reus or illegal act or omission to be classified as a crime. The act of doing something bad, actus reus, must be usually accompanied by the intention to do something bad, mens rea. A crime is said to exist usually when both these elements are present. The principle of actus reus and mens rea are embedded in a Latin maxim, which is actus non iacet reum nisi mens sit rea. This Latin maxim means that an act does not make one guilty unless the mind is also legally blameworthy. In other words, for a physical act to be termed a crime, it must be accompanied by the necessary mental element. Unless this mental element is present, no act is usually criminal in nature. So, all crimes have a physical element and a mental element, usually called actus reus and mens rea respectively. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In. Unit I. Unit 2. Unit 3. UNITIV. Unit V. 114. Unit V. Unit 7. Unit 8. What is actus reus? The word actus connotes a deed, which is a physical result of human conduct. The word reus means forbidden by law. Actus reus in common parlance means a guilty act. It is made up of three constituent parts, namely, 1. An action or a conduct. 2. The result of that action or conduct. 3. Such act, conduct being prohibited by law. Therefore, one can say that actus reus is an act which is bad or prohibited, blameworthy or culpable. Now, there are certain unique situations when the act in itself may appear to be a criminal act, yet it cannot be termed as actus reus. Illustrations. An executioner's job is to hang, no actus reus. An army man kills as a part of his duty, no actus reus. Does an act in actus reus include omissions? An omission is nothing but an action or not doing something. Section 32 in the Indian Penal Code. 32. Words referring to acts include illegal omissions. In every part of this code, except where a contrary intention appears from the context, words which refer to acts done extend also to illegal omissions. Section 32 of the Indian Penal Code, IPC, clarifies that acts which may be considered as crime include illegal omissions. But mere moral omissions of not doing something would not complete the requirement of actus reus. Illustration. A boy is drowning in the swimming pool of a resort. A man who is beside the pool does not make any attempt to save this boy. This is a moral omission of not saving someone's life. The man cannot be held criminally liable for such an omission. But in the same scenario, if there is a lifeguard on duty at this resort, and if he does not make any attempt to save the boy drowning in the pool, then he can be held criminally liable for such omission. What is mens rea? Mens rea generally means ill intention, guilty mind, intent. The constituents of mens rea are 1. There must be a mind at fault, intention to constitute a crime. 2. The act becomes criminal when the actor does it with a guilty mind. Note: causing injury to an assailant in self-defense is not a crime, but the moment injury is caused with intent to take revenge, the act becomes criminal. Therefore, for any crime to exist, the physical element of crime needs to be complemented by the mental element. The concept of mens rea evolved in England during the 17th century. During this Textbook of Legal Studies 12-2023-2024. www. CBC Academic. NIC. In 115. Unit I. Unit 2. Unit 3 UNITIV UNITV. Unit V Unit 7 Unit 8. Period. The judges began to hold that an act alone could not create criminal liability unless it was accompanied by a guilty state of mind. In India, the word mens rea, as such, is not defined in the IPC, but its essence is reflected in almost all the provisions of the code. For framing a charge for an offense under the IPC, the traditional rule of existence of mens rea is to be followed. This rule has been reiterated by the Supreme Court of India in State of Maharashtra v. Mayor Hans George, Air 1965 SC 722. Facts of the case: the respondent, Mayor Hans George, a German smuggler, left Zurich by plane on the 27th of November 1962 with 34 kilos of gold concealed on his person to be delivered in Manila. The plane arrived at Bombay on 28th of November. The customs authorities, as a part of their duties, inspected to check if any gold was dispatched by any traveler and looked through George, seized his gold and accused him of the offense under Sec 8, 10, and 23, 1A, of the Foreign Exchange Regulation Act. This section is read with a notification dated November 8, 1962, of the RBI which was published in the Gazette of India on 24th of November. George was initially acquitted by the High Court, but the further appeal was made by the state in the court of law. Issues presented before the court whether the respondent is guilty of bringing gold in India under Sec 8, 1, and 23, 1A, of the FERA which was published in the Gazette of India on the 24th of November 1962. The state of Maharashtra contended that the act was passed keeping in mind the pirating of gold since it has become the major financial concern of the nation. Moreover, looking at the importance of the act, it can be inferred that the mens rea is an irrelevant element in assuming the culpability of the offender. The strict adherence of the Act refutes such assumptions and demonstrates that mens rea is not a fundamental element of the offense. However, the respondents were of the view that mens rea is a fundamental element of any criminal offense, and George was not aware of the notification published by the Reserve Bank. It was contended that a person who was not aware of the Indian provision and has no intention to bring gold in India cannot be said to possess the intent to break the law and hence should not be prosecuted under the Act. Decision. It was held in this case that mens rea by necessary implication can be excluded from a statute only where it is absolutely clear that the implementation of the object of a statute would otherwise be defeated, and its exclusion enables those put under strict liability by their act or omission to assist the promotion of the law. The court said that even though mens rea is an essential requirement to commit a crime, but regardless of that, the statutory provision can exclude the mental element. The express words of the statute can exclude the mens rea as an essential ingredient of the crime. This may be done for various reasons, for instance, to promote public welfare and activities or to eradicate social evils. The statute which complies strict liability helps the offender to assist the state in the enforcement of the law. 1.2 Distinction between intention and motive. As we have seen, intention or mental element is one of the foremost requirements in order to make someone liable for a crime. But a common misconception is that motive and intention are the same concepts when it comes to crime. Thus, it is important to understand the fine distinction between these two terms. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In. Unit I. Unit 2. Unit 3. UNITIV. Unit V. 116. Unit V. Unit 7. Unit 8. In Re Srirangai Case 1973-1 M. L. J. 231, the woman in sheer destitution and impoverishment attempted to kill herself after failing in all the ways to arrange for food for her starving children, but since she knowingly, mens rea, did a prohibitive act of attempting suicide, actus reus, she was held guilty by the court. The meaning of doing an act intentionally in criminal law means something that is done willfully and not accidentally or mistakenly. The person doing the act is well aware of the consequences or the outcomes of his action or omission. That is all what is required for affixing criminal liability. It does not matter, as we say in ordinary language, whether an act was done with good intent or bad intent. If the act which is prohibited, actus reus, is done willfully, knowingly or with awareness of the resulting consequences, then the same will cause liability in criminal law. Motive, on the other hand, is the ulterior objective behind doing an act. It is the driving force behind intention or commission of an act. The criminal law does not take into account motive in affixing criminal liability or in determining criminal culpability. This is the reason why the criminal law does not care whether one has stolen a loaf of bread to feed a starving person or stolen medicine to save someone's life, as long as it is a prohibited act, done knowingly. In Nathuni Yadav and Ozvi State of Bihar and another 1997 SC 34 ACC 576, the court held that motive for doing a criminal act is generally a difficult area for prosecution. One cannot normally see into the mind of another. Motive is the emotion which impels a man to do a particular act. Such impelling cause need not necessarily be proportionally grave to do grave crimes. Many a murder have been committed without any known or prominent motive. The court further stated that motive is a psychological phenomenon. Merely because failing to translate the mental state of the accused does not mean that no such mental condition existed in the mind of the assailant. The motive for an offense need not be necessarily proportionately grave to commit the grave offense. Therefore, establishing a sufficient motive for committing the offense is not a prerequisite for conviction. 1.3 Stages of crime. Any crime has a few key stages to it, as indicated in the box alongside. Ordinarily, the first two stages, intention and preparation, do not give rise to any form of criminal liability. This implies that merely having an intention to commit a criminal act is not punishable, nor is making preparation for the same. Liability in criminal law arises when one goes beyond the stage of preparation and attempts to do the forbidden act. The stages can be explained as under intention. The first stage in committing a crime is to have criminal intent and thus is known as mental stage. The law does not take notice of an intention. Mere intention to commit an offense not followed by any act cannot constitute an offense. The obvious reason for not prosecuting the accused at this stage is that it is very difficult for the prosecution to prove the guilty mind of a person. Preparation. The second stage refers to arranging all the essential steps to carry out the intended criminal act. Preparation is not unlawful in itself since it is difficult to prove that the essential preparations were made for the commission of the crime. However, in some exceptional circumstances, mere preparation is also punished. Intention, first stage of crime, preparation second stage of crime, attempt third stage of crime, commission final stage of crime, Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In 117. Unit I. Unit 2. Unit 3 UNITIV. Unit V. Unit 7 Unit 8. Preparation when punishable. When the offense is regarded as a serious offense, preparation to commit offenses is penalized under the Indian Penal Code. A few of them are mentioned below. Collecting arms etc. With intention of waging war against the Government of India, Section 122 of IPC. Preparing Indian coins or government stamps for counterfeiting, Sections 233 to 235, 255, and 257 of IPC. Possession of counterfeit coin, counterfeit government stamp of false weight or measure, Sections 242, 243, 259, 266 of IPC. Making preparations to commit dacoity, Section 399 of IPC. Attempt. The third stage in the conduct of a crime is attempt, and it is punishable. The criminal liability arises only when the crime has reached the stage which is gone beyond preparation and has entered into the domain of attempt. Section 511 of the IPC does not define the term attempt, although it does impose a penalty for attempting to commit an offense. After making necessary preparations, an attempt is defined as a direct step towards the commission of a crime. Commission of crime. Committing the crime is the final step in the process. If the accused succeeds in his attempt, he commits a crime and will be found guilty of it. If he fails, he will only be charged with attempting. If the crime is complete, the offender will be tried and punished as per the specific provisions provided in the Indian Penal Code. As mentioned above, the Indian Penal Code, IPC, covers the substantial part of criminal law in India. It defines various common criminal offenses. For example, it defines murder, theft, assault, and a number of other offenses and also stipulates appropriate punishments for each offense. For instance, the offense of theft is defined in the following language in Section 378 of the IPC: whoever dishonestly intends to take any movable property out of the possession of any person without that person's consent, and with that intention, moves that property in order to commit such taking, is said to commit theft. In other words, a crime of theft is committed if someone intends to take someone else's property and indeed takes that property without the other person's consent. Merely intending to take somebody's property, without actually going ahead with the act, does not amount to theft. The punishment for theft is stipulated in the following Section 379, which states, whoever commits theft shall be punished with imprisonment for a term which may extend to 3 years, or with fine, or with both. Different crimes carry different punishments according to the severity of the offense. For instance, the punishment for murder is either death or life imprisonment. This is the way that most of the IPC is organized. First, a definition of an offense is provided, and next the punishment for that offense is stipulated. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In Unit I. Unit 2. Unit 3. UNITIV. Unit V. 118. Unit V. Unit 7. Unit 8. Crimes under the special and local laws. Certain acts are to be considered criminal acts even when they are not to be found in IPC. This is because they have been identified as crimes in special and local laws. An illustrative list of such statutes is in the table below. I. Arms Act, 1959. 2. Narcotic Drugs and Psychotropic Substances Act, 1985. 3. Gambling Act, 1867. IV. Excise Act, 1944. V. Prohibition Act. V. Explosives and Explosive Substances Act, 1884 and 1908. 7. Immoral Traffic Prevention Act, 1956. 8. Railways Act, 1989. X. Registration of Foreigners Act, 1930. X. Protection of Civil Rights Act, 1955. 11. Indian Passport Act, 1967. 12. Essential Commodities Act, 1955. 13. Terrorist and Disruptive Activities Act. 14. Antiquities and Art Treasures Act, 1972. 15. Dowry Prohibition Act, 1961. 16. Child Marriage Restraint Act, 1929. 17. Indecent Representation of Women Prohibition Act, 1986. 18. Copyright Act, 1957. 19. Sati Prevention Act, 1987. XX. SC/ST, Prevention of Atrocities Act, 1989. 21. Forest Act, 1927. 22. Other crimes, not specified above, under special and local laws including cyber laws under Information Technology Act, IT 2000. 2. Criminal Procedure Code, 1973, CRPC. The object of the Criminal Procedure Code is to provide a mechanism for the investigation and trial of offenders. It lays down the rules for conduct of investigation into offenses by the police proceedings in court against any person who has committed an offense under any criminal law, whether it is IPC or a crime classified under any other law. See Part 1, Legal Studies Class 11. Types of offenses covered. All such offenses are covered by CRPC which are mentioned in Indian Penal Code. As already seen, the legal meaning and whether an act will constitute a criminal offense or not is provided in the IPC. The procedure of initiating proceeding, prosecution for a criminal offense is provided in Criminal Procedure Code, CRPC. CRPC provides the manner and place where investigation, inquiry and trial of an offense shall take place. Textbook of Legal Studies 12-2023-2024. www.cbckademic. NIC. In 119. Unit I. Unit 2. Unit 3 UNITIV UNITV. Unit V Unit 7 Unit 8. Most accused persons do not lead defense evidence in India. One of the major reasons for this is that in India, the burden is cast on the prosecution to prove the offense and the degree of proof required in a criminal trial is proof beyond reasonable doubt. This is quite a high standard that the prosecution must meet. It is not enough for the prosecution to assert that the accused has committed the offense. The judge must be convinced beyond reasonable doubt that it was in fact the accused who committed the offense. This was known as the golden thread principle of criminal law. This idea is currently recognized in the criminal law of several common law nations, including the United Kingdom, Canada, South Africa, the United States of America, and India. Reverse onus clauses shift the burden of proof from the prosecution to the defendant when the prosecution has shown certain essential facts. While the presumption of the accused's innocence is a long-standing principle enshrined in common law and upheld by Indian law as well, jurists have developed a rebuttal to the presumption of innocence under which an accused may be presumed guilty at first instance and the burden of proof is on the defense to establish the accused's innocence or raise a reasonable doubt as to his guilt. The definition of a reverse onus provision is one that shifts the burden of proof from the prosecution to the accused once the prosecution establishes a fundamental truth that justifies the shift in burden. Although it isn't expressly stated in any laws, the presumption of innocence is an accepted concept in Indian criminal law. There are certain categories of infractions as well to the existence of the Golden Rule. In certain situations, the burden of proof is placed on the accused to present evidence supporting his innocence or to raise a plausible doubt about his guilt. The accused is prima facie considered guilty. In India, the presumption of innocence is overturned in two situations. First, when a specific statute explicitly reverses the burden of proof, and second, when the accused files an appeal against a lower court's decision in which his assumption is guilt rather than innocent. Dowry death is the most well-known instance of a reversal onus provision in our nation. In dowry death cases, the accused is believed to be in a guilty mental state, establishing a presumption of guilt rather than the ordinary presumption of innocence. 3. The Indian Evidence Act, 1872. The Indian Evidence Act stipulates how facts can be proved through evidence. The function of the law of evidence is to lay down rules according to which the facts of a case can be proved or disproved before a court of law. The Evidence Act lays down the rules of evidence for the purposes of the guidance of the courts. The Evidence Act helps the judges to separate the wheat from the chaff, and plays a crucial role in the establishment of facts during the court proceedings. What evidence can be admitted, how it can admit, how the burden of proof has to be discharged, etc., are matters governed by the Evidence Act. The main principles which form the foundation of law of evidence are: evidence must be confined to the matter at hand. Hearsay evidence must not be admitted. Best evidence must be given in all cases. One of the main objectives of the Evidence Act is to prevent the inaccuracy in the admissibility of evidence and to introduce a more correct and uniform rule of practice. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In. Unit I. Unit 2. Unit 3. UNITIV. Unit V. 120. Unit V. Unit 7. Unit 8. The Act is divided into three parts. Part 1. Relevancy of facts, or what facts may or may not be proved. These are dealt with in detail in sections 5 to 55. Part 2. How the relevant facts are to be proved. The part deals with matters which need not be proved under law, and also how facts in issue or relevant facts are proved through oral and documentary evidence. Sections 56 to 100. Part 3. By whom and in what manner must the evidence be produced. It deals with the procedure for production of evidence and the effects of evidence. Sections 101 to 167. 3.1. Admission and confession. Sections 17 to 31 deal with admission generally and includes sections 24 to 30 which deal with confession as distinguished from admission. Section 17(0)(f) The Indian Evidence Act defines that an admission is a statement either oral or documentary or contained in electronic form which suggests an inference as to a. any fact in issue, or b. relevant fact. Confession. The word confession appears for the first time in Section 24 of the Indian Evidence Act. This section comes under the heading of admission, so it is clear that the confessions are merely one species of admission. The term confession is not defined in the Evidence Act. Justice Stephen, in his Digest of the Law of Evidence, states, a confession is an admission made at any time by a person charged with a crime stating or suggesting the inference that he committed that crime. Difference between confession and admission. Confession, admission. 1. Sections 24 to 30 of Indian Evidence Act deal with confession. A confession is only a species of admission. 1. Sections 17 to 31 of Indian Evidence Act deal with admission. Since the provisions relating to confessions occur under the heading admission, it follows that the word admission is more comprehensive and includes a confession also. 2. If a statement is made by a party charged with crime in criminal proceeding, it will be called confession. 2. If a statement is made by a party in civil proceeding, it will be called admission. 3. The expression, confession, means a statement made by an accused admitting his guilt. Confession is a statement made by an accused person which is sought to be proved against him in criminal proceeding to establish the commission of an offense by him. 3. The expression, admission, means voluntary acknowledgement of the existence or truth of a particular fact. 4. If the confession made is free and voluntary, then it may be accepted as conclusive proof of the matters confessed. 4. Admissions are not conclusive proof as to the matters admitted. Textbook of Legal Studies 12-2023-2024. www.cbckdemic. NIC. In 121. Unit I. Unit 2. Unit 3 UNITIV. Unit V. Unit 7. Unit 8. 5. Confessions always go against the person making it. 5. Admissions may be used on behalf of the person making it. 6. By virtue of the provision in Section 30, the confession of an accused person is relevant against all his co-accused who are being tried with him for the same offense. 6. In admission, statements of a co-plaintiff or those of a co-defendant are no evidence against the others. 3.2 Forms of confession. A confession may occur in many forms. When it is made to the court itself, then it will be called judicial confession, and when it is made to anybody outside the court, it will be called extrajudicial confession. It may even consist of conversation to oneself, which may be produced in evidence if overheard by another. For example, in Sahu v. State of UP. AIR 1996 SC 40, the accused who was charged with the murder of his daughter-in-law with whom he was always quarreling was seen on the day of the murder going out of the house, saying words to the effect, "I have finished her and with her the daily quarrels." The statement was held to be a confession relevant in evidence, for it is not necessary for the relevancy of a confession that it should be communicated to some other person. Judicial confessions are made before a magistrate or in court in the due course of legal proceedings. A judicial confession has been defined to mean plea of guilty on arrangement, made before a court, if made freely by a person in a fit state of mind. Extrajudicial confessions are made by the accused elsewhere than before a magistrate or in court. It is not necessary that the statements should have been addressed to any definite individual. It may have taken place in the form of a prayer. It may be a confession to a private person. An extrajudicial confession has been defined to mean a free and voluntary confession of guilt by a person in a fit state of mind, accused of a crime in the course of conversation with persons other than judge or magistrate seized of the charge against himself. For example, a man after the commission of a crime may write a letter to his relative or friend expressing his grief over the matter. This may amount to confession. Extrajudicial confession can be accepted and can be the basis of a conviction only if it passes the tests of credibility as laid down in the procedural laws. 3.3. Dying declaration, statements by persons who cannot be called as witnesses. Dying declaration is a legal concept that refers to the statement which is made by a dying person explaining the circumstances of his death. It is a statement by a person who is conscious and knows that death is imminent concerning what he believes to be the cause or circumstances of his death. It is also considered credible and trustworthy evidence based upon the general belief that most people who know that they are about to die, do not lie. Section 32 of the Indian Evidence Act deals with the admissibility of dying declaration. It deals with cases in which statements of relevant fact by person who is dead or cannot be found etc. is relevant. 1. When it relates to cause of death. When the statement made by a person as to the cause of his death, or as to any of the circumstances of the transaction which resulted in his death, in cases in which the cause of that person's death comes into question. Such statements are relevant whether the person who made them was or was not, at the time when they were made. Textbook of Legal Studies 12-2023-2024. www.cbckdemic. NIC. In. Unit I. Unit 2. Unit 3. UNITIV. Unit V. 122. Unit V, Unit 7, Unit 8. Under expectation of death, and whatever may be the nature of the proceeding in which the cause of his death comes into question. In K.R. Reddy v. The Public Prosecutor SC 1976, Air 1994, the evidentiary value of dying declaration was observed as under. The dying declaration is undoubtedly admissible under Section 32 of the Evidence Act and not being a statement on oath so that its truth could be tested by cross-examination, the courts have to apply the strictest scrutiny before acting upon it. While great solemnity and sanctity is attached to the words of a dying man because a person on the verge of death is not likely to tell lies or to concoct a case so as to implicate an innocent person, yet the court has to be on guard against the statement of the deceased being a result of either tutoring, prompting, or a product of his imagination. 1. The court must be satisfied that the deceased was in a fit state of mind to make the statement after the deceased had a clear opportunity to observe and identify his assailants and that he was making the statement without any influence. 2. Once the court is satisfied that the dying declaration is true and voluntary, it can be sufficient to found the conviction even without any further corroboration. The court laid down the following general propositions. 1. If the dying declaration is coherent, consistent and trustworthy and appears to have been made voluntarily, conviction can be based on it even if there's no corroboration. R. Money v. State of TN. 2006 SC. 2. Each case must go by its own facts. 3. A dying declaration is not a weaker kind of evidence than any other piece of evidence. 4. A dying declaration which has been properly recorded by a competent magistrate, in the form of questions and answers, and as far as practicable in the words of the maker of the declaration is reliable. Exercises. Based on your understanding, answer the following questions. 1. A. An alleged offender of rape, while in police remand, felt pain in his chest. He was admitted in a hospital, where a police constable was kept on the gate to keep a watch on him. A. Confessed his guilt before another patient X, who was also in the same room. The statement was overheard by policeman also. Prosecution wants to make the statement of a as confession. 2. Vijay is accused of murder of his friend, Ajay. Vijay, who was missing since the death of Ajay, is alleged to have phoned the police, in a repentant mood after consuming some liquor from a hotel nearby city, confessing his crime. Prosecution wants to prove the alleged murder on the basis of the statement. Can the prosecution do so? Discuss. 3. State the correct proposition of law together with precautions that courts should take in dealing with dying declarations. 4. X was convicted under Section 302 of IPC for having committed murder of his wife Y. The judgment of trial court is based on the dying declarations made by Y to the police officer and metropolitan magistrate who visited the hospital later on. Can the accused be convicted solely on the basis of the dying declaration given by Y? Explain with the help of relevant case. 5. Crime is a revolt against whole society and an attack on the civilization of the day. Elucidate and discuss the essential elements of crime. 6. Explain mens rea as an element of criminal liability. Is mens rea relevant in crimes of strict liability? Discuss with the help of decided case law. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In 123. Unit I. Unit 2. Unit 3 UNITIV UNITV. Unit V Unit 7 Unit 8. Activity. Make a brief study on the following questions by gathering opinions of at least 5 of your classmates, friends or family members. 1. Do you think imposition of capital punishment in the rarest of the rare cases justified? 2. Is death penalty an effective crime deterrent? Mention their responses in the given table below and draw conclusions on the basis of those responses. What is your opinion regarding these issues? Questions. Responses of persons. Respondent 1, Respondent 2, Respondent 3, Respondent 4, Respondent 5. Question 1. Question 2. Bibliography: Kenny's Outlines of Criminal Law, J.W. Cecil Turner, Prof. S. N. Mishra. Indian Penal Code. Central Law Publications, Allahabad, 10th edition, September 2001. K. D. Gore. A textbook of the Indian Penal Code, Universal Law Publishing Company Private Limited, New Delhi, 3rd edition 2004. O. P. Srivastav. Principles of Criminal Law, Eastern Book Company, Lucknow, 5th edition, 2010. Gore Dr. K. D. 2013, Commentary on the Indian Penal Code, 2nd edn. Universal Law Publishing Co. PVT. Limited. Monica Sakhrani, 2009, Citizen's Guide to Criminal Law, reprint, Universal Law Publishing Co. PVT. Limited. Bharati, Dilbir, 2005. The Constitution and Criminal Justice Administration. APH Publishing, Menon, N. R. Madhava. Banerjee, D. West Bengal National University of Juridical Sciences, 2005. Criminal Justice India Series, PTS. 1-2. Chandigarh. Allied Publishers. Web. Web links, web links, web links, web links. HTML, Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In. Unit I. Unit 2. Unit 3. UNITIV. Unit V. 1-4. Unit V. Unit 7. Unit 8. Unit 5. Concept of Human Rights. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In 127. Unit I. Unit 2. Unit 3. Unit IV. UNITV. Unit V. Unit 7. Unit 8. Human Rights in India. Learning outcomes. Students will be able to understand the meaning of rights and human rights, differentiate between human rights and fundamental rights, appreciate the significance of Universal Declaration of Human Rights, understand the link between Sustainable Development Goals and human rights, understand how human rights laws are rooted in its constitution in India, discuss various kinds of human rights that are safeguarded by laws in India. This unit consists of two main chapters, one on the human rights laws in India, Indian Constitution and statute laws, and the other on the human rights commissions and their complaint mechanisms. The focus of this sub-unit is on human rights laws in India. A. Introduction. 1. Historical context. Historically, varied religious and social traditions as well as philosophical writings have recognized in different ways and with diverse perspectives the inherent rules of being humans, particularly the principles that ensure respect for human dignity. Such principles have commonly been understood as basic and unalienable. For example, traditions like Christianity, Islam, Hinduism, Buddhism, and Confucian have made reference to respect and well-being for others, which mean that human beings must conduct themselves in particular ways. The modern society, also, has recognized certain rules of respecting human dignity and their well-being and formulated them in the form of human rights. Generally, the word rights denote that these rules are entitlements or claims of all to be recognized and protected through duties and obligations, and the state ensures that human rights of all are guaranteed. Human rights are standards that recognize and protect the dignity of all human beings. Human rights govern how individual human beings live in society and with each other, as well as their relationship with the state and obligations that the state has towards them. Human rights are based on values that keep society fair, just and equal. They include the right to life, the right to health and the right to freedom from torture etc. How did the story of human rights begin? The origin of human rights began in the year 539 BC when troops of Cyrus the Great conquered Babylon. After winning the war, Cyrus did something unexpected. He freed the slaves to return home. He also declared that all people had the right to choose their own religion. Chapter 5, A. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In. Unit I. Unit 2. Unit 3. Unit IV. UNITV. 128. Unit V, Unit 7, Unit 8. In the 20th century, during the Second World War, the world saw barbarous acts that outraged the conscience of mankind. In December 1948, this resulted in the adoption of Universal Declaration of Human Rights, UDHR, by the then newly established United Nations that recognized human rights to be the foundation for freedom, justice and peace. E. What is a right? A. Right is a moral or legal entitlement to have or do something. A right is a justified claim on others. In other words, rights are reasonable privileges or claims of people which are accepted by society and affirmed by statute. Rights include human rights and fundamental rights. E. What are human rights? Human rights are basic rights that we have because we exist as human beings. These are not granted by any state. Human rights belong to all human beings irrespective of their nationality, race, caste, creed, gender, etc. All individuals enjoy same human rights, without any discrimination. Human rights are safeguards that a human being seeks in order to live with dignity and equality. Therefore, human rights are universal and inalienable rights. The principle of universality of human rights means that we are all equally entitled to our human rights. Human rights are inalienable. Therefore, these should not be taken away, except in specific situations and according to due process. For instance, the right to liberty may be restricted if a person is found guilty of a crime by a court of law. A few examples of human rights are those basic rights that ensure fairness, equality, freedom and respect to all people. These rights abolish various unjust practices like exploitation, discrimination and inequality. Human rights include most fundamental rights like right to life, rights to food, education, work, health, and liberty etc. Human Rights Logo. The Cyrus Cylinder. It is a clay tablet containing statements of Cyrus, the Great. It is the first human rights declaration in history. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In 129. Unit I. Unit 2. Unit 3. Unit IV. UNITV. Unit V. Unit 7. Unit 8. IV. International Human Rights. In 1948, the United Nations General Assembly adopted Universal Declaration of Human Rights, UDHR, as a common standard of achievement for all peoples and nations. The Universal Declaration of Human Rights provides and defines various kinds of human rights that are applicable to all human beings. These include the fundamental, civil, political, economic, social and cultural rights, for example freedom of speech, assembly, conscience and religion. Right to education. Right to livelihood and decent standard of living. Right to life, liberty and security of person. Right to equality. Freedom from all forms of discriminations including based on gender and race. And so on. The principle of universality of human rights is the cornerstone of international human rights law. The Universal Declaration of Human Rights has been embraced by almost all member states of the United Nations. All member states have committed to respect and protect the basic human rights values provided therein. What are fundamental rights? Fundamental rights are basic rights of the citizens of a country. Fundamental rights are enshrined in the Constitution and they are enforceable in the court of law. If there is any kind of violation of fundamental rights, one can approach the court for protection of such rights. Difference between fundamental rights and human rights. The main difference between fundamental rights and human rights is that the fundamental rights are specific to a particular country, whereas human rights have worldwide acceptance. Basis for comparison. Fundamental rights. Human rights meaning fundamental rights are the basic rights of citizens of a country which are stated in the Constitution and enforced by law. These may slightly vary from country to country. Human rights are the basic rights that all human beings can enjoy, regardless of their nationality, ethnicity and religion etc. Scope. It is country specific. It is universal. Fundamental rights and human rights are important to create a better environment for people and to help them preserve their dignity. Textbook of Legal Studies 12-2023-2024. www. CBC Academic. NIC. In. Unit I. Unit 2. Unit 3. Unit IV. UNITV. 130. Unit V. Unit 7. Unit 8. V. Sustainable Development Goals and Human Rights. The Sustainable Development Goals, SDGs, and human rights are interlinked. Over 90% of the goals of the SDGs relate to human rights obligations. When a state makes progress towards achieving SDGs, they move forward to fulfill their human rights obligations. Few SDGs that are linked to human rights are: no poverty, gender equality, zero hunger. B. Indian Constitutional Framework on Human Rights and Related Laws in India. In India, human rights are rooted in its constitution just like the US, South Africa, and many other countries. The Indian Constitutional Human Rights Framework involves the following parts. 1. The Preamble. 2. Fundamental Rights. Part 3 of the Constitution contains the Fundamental Rights. 3. Directive Principles. Part 4 of the Constitution contains Directive Principles. And 4. Fundamental Duties. Part 4a contains fundamental duties. 1. The Preamble. The Constitution of India begins with the preamble affirming its aims, objectives, and the guiding principles. The principles laid out in the preamble are used for interpreting provisions of the Constitution that are vague and ambiguous. The preamble is the basic structure of the Constitution. The doctrine of basic structure takes away the amendment power of the Parliament with regards to certain features of the Constitution such as democracy, rule of law, secularism, separation of powers, and judicial review. Some of these features appear in the preamble. The preamble proclaims the rights and freedoms, provisions of which are contained in the Constitution in various parts and clauses aimed to secure to all its citizens those rights and freedoms. 2. Fundamental Rights, Part 3 of the Constitution. Articles 12 to 35 in Part 3 of the Constitution contain the provisions on fundamental rights. Fundamental rights are largely civil and political rights. The fundamental rights in India consist of the following rights: a. Right to equality, Articles 14 to 18b, right to freedom, Articles 19 to 22c, right against exploitation, Articles 23 to 24d, right to freedom of religion, Articles 25 to 28a, cultural and educational rights, Articles 29 to 30f, right to constitutional remedies, Articles 32, Textbook of Legal Studies 12-2023-2024. www. CBC Academic. NIC. In 131. Unit I. Unit 2. Unit 3. Unit IV. UNITV. Unit V. Unit 7. Unit 8. Some of the salient features of fundamental rights are listed below. Fundamental rights are enforceable by the higher courts in India. Article 32 provides the right to the aggrieved ones, whose fundamental rights have been violated or denied, to petition the Supreme Court for the enforcement of fundamental rights. Article 13 elevates the authority of fundamental rights. It ensures that the state or other competent authority do not make laws including ordinances, orders, bylaws, rules, regulations, notifications, customs or usages that contradicts or takes away or breaches the fundamental rights. Fundamental rights are mostly enforceable against the state and in some cases against private persons. An example of the former is the right to freedom of speech and expression. For the latter is the prohibition of employment of children below the age of 14 years in factories, mines, and in places of hazardous activities. The term state includes the government, parliament, state legislatures, district boards, panchayats, municipalities, and other authorities or organizations that are an instrument or agency of the state like the Indian Oil Limited, Karnataka State Road Transportation Authority, Delhi Jal Board, and so on. What is a state? Article 12 defines the term state. Article 12 of the Indian Constitution states that, definition in this part, unless the context otherwise requires, the state includes the Government and Parliament of India and the government and the legislature of each of the states and all local or other authorities within the territory of India or under the control of the Government of India. For the purposes of Part 3 of the Constitution, the state comprises of the following: Government and Parliament of India I. The Executive and Legislature of the Union, Government and Legislature of each state I. The Executive and Legislature of the various states of India, or local or other authorities within the territory of India, or local and other authorities who are under the control of the Government of India. Let us now understand various fundamental rights in detail. Right to equality, Articles 14 to 18. Article Brief Description. Article 14. The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India, on grounds of religion, race, caste, sex or place of birth. Article 15. The state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth or any of them. Article 16. There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. Article 17. Abolition of untouchability. Article 18. Abolition of all titles except military and academic. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In. Unit I. Unit 2. Unit 3. Unit IV. UNITV. 132. Unit V. Unit 7. Unit 8. Article 14. Article 14 provides to all the right to equality before law and equal protection of the law. It prohibits discrimination on grounds of religion, race, caste, sex or place of birth. It means that law treats everyone equally without consideration of their rank or status or other backgrounds. Equality principle. The principle of equality means that one uniform law cannot be applied to all equally as some may not be similarly placed as others. So, equality treats equals similarly and unequals differently. Although Article 14 states equality before law, that does not mean absolute equality. The application of the equality principle cannot be universal or general in character. This means that the same law cannot apply to every person equally and similarly. Different situations may require different treatment. Therefore, the same law may not apply to everyone but only to a class of people. The state is entitled to make a reasonable classification for purposes of legislation and treat all in one class on an equal footing. For example, the Prohibition of Child Marriage Act, 2006 prescribes the marriageable age of girls is 18 years and that of boys is 21 years. This restricts a minor from getting married. This example draws a distinction based on age in relation to the question of the prohibition of child marriage. However, if the marriage between two parties were to be disallowed based on the classification of religion, race, caste, sex or place of birth, it would amount to discrimination and breach of right to equality. Article 15. Discrimination and access to public places. Article 15 is based on the equality principle. It prohibits state from discriminating anyone based on grounds of religion, race, caste, sex or place of birth. Also, it prohibits anyone and the state from using these grounds to restrict any citizen from entering shops, public restaurants, hotels and places of public entertainment, or the use of wells, tanks, bathing ghats, roads and places of public resort. Article 16. Reservation and affirmative action. Article 16 is also based on the equality principle of Article 14. It provides for equality of opportunity in matters of public or state employment and bars any discrimination to any citizen on grounds of religion, race, caste, sex, descent, place of birth, or residence. However, this article allows the state to provide reservation or affirmative action programs for government jobs to backward classes like scheduled castes and scheduled tribes who, because of historical and continued disadvantages based on caste, status and otherwise have not been adequately represented in the services under the state. Article 17. Abolition of untouchability. Under Article 17, untouchability is abolished and its practice in any form is forbidden. Textbook of Legal Studies 12-2023-2024. www. CBC Academic. NIC. In 133. Unit I. Unit 2. Unit 3, Unit IV, UNITV, Unit V, Unit 7, Unit 8. This article can be enforced against both the state as well as private individuals. The offense of untouchability is punishable in accordance with special laws like the Protection of Civil Rights Act, 1955 and Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act, 1989. The abolition of untouchability in Article 17 is made operational by these two special laws that attempt to remove any form of harassment and abuses to Dalits and Adivasis by the state or private individuals. Article 18. Abolition of titles. Article 18 talks about the abolition of titles. It states, no title, not being a military or academic distinction, shall be conferred by the state. No citizen of India shall accept any title from any foreign state. No person who is not a citizen of India shall, while he holds any office of profit or trust under the state, accept without the consent of the President any title from any foreign state. No person holding any office of profit or trust under the state shall, without the consent of the President, accept any present, emolument, or office of any kind from or under any foreign state. B. Right to freedom. Articles 19 to 22. Article 19. Article 19 prescribes and protects the following kinds of freedoms to all citizens. A. Freedom of speech and expression. B. Freedom to assemble peaceably and without arms. C. Freedom to form associations or unions. D. Freedom to move freely throughout the territory of India. A. Freedom to reside and settle in any part of the territory of India. And F. Freedom to practice any profession, or to carry on any occupation, trade or business. Textbook of Legal Studies 12-2023-2024. www. CBC Academic. NIC. In Unit I. Unit 2. Unit 3, Unit IV. UNITV. 134. Unit V, Unit 7, Unit 8. Reasonable restrictions on freedoms under Article 19. Article 19 also provides reasonable restrictions on these freedoms, which means that these rights are conditional. The state can reasonably limit or take away the right to freedom of speech and expression when there is a threat to the sovereignty and integrity of India, or the security of the state, or friendly relations with foreign states, or public order, or decency or morality, or in relation to contempt of court, or defamation, or incitement to an offense. For example, the state can prohibit someone from making inciting speeches that may provoke others to commit violence. The chart below presents the various conditions under which the state can limit or take away freedoms. Freedoms, restrictions, grounds. Freedom of speech and expression, sovereignty and integrity of India, or the security of the state, or friendly relations with foreign states, or public order, or decency or morality, or contempt of court, or defamation, or incitement to an offense. Freedom to assemble peaceably and without arms. Sovereignty and integrity of India, or public order. Freedom to form associations or unions. Sovereignty and integrity of India, or public order or morality. Freedom to move freely throughout the territory of India. Interests of the general public, or for the protection of the interests of any scheduled tribe. Freedom to reside and settle in any part of the territory of India. Freedom to practice any profession, or to carry on any occupation, trade or business. Interests of the general public, or the state prescribed professional or technical qualifications, or state-run trade, business, industry or service, that excludes participation of citizens or others either completely or partially. However, at times the Supreme Court can invalidate states' restrictions if it finds them to be unreasonable. As an instance, the state cannot put restriction as an excuse because it is unable to maintain public order, e.g., application of aforementioned restrictions on the sale of a book because of a few unruly protesters. Such restrictions are unreasonable and breach the right to freedom of speech and expression of the author. Point to ponder. Do criminals have human rights? Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In 135. Unit I. Unit 2. Unit 3. Unit IV. UNITV. Unit V. Unit 7. Unit 8. Human Rights Framework to the Criminal Justice System. Article 20. Rights of persons accused of crimes. Article 20 provides for safeguards to persons who are accused of having committed crimes. This article provides the human rights framework to the criminal justice system. The rights of persons accused of crimes are: firstly, Article 20 provides that no person can be convicted for the commission or omission of an act that does not amount to an offense by any law in force at the time of such act. For example, sodomy law under Section 377 of the Indian Penal Code, IPC, treated consensual homosexual conduct between same-sex adults as a criminal offense. In 2009, Section 377 was declared invalid and unconstitutional by the Delhi High Court to protect rights to privacy, non-discrimination, and liberty of lesbian, gay, bisexual and transgender people. But in 2013, the Supreme Court reversed the High Court's decision. However, in 2018 the Supreme Court overturned its 2013 judgment and struck down Section 377 of the IPC as unconstitutional. In this example, sodomy law will not apply to any consensual homosexual conduct committed in 2011 but will apply to commissions that took place post-Supreme Court judgment of 2013 till 2018, when the law again changed. Therefore, Article 20 prohibits application of laws retrospectively and prospectively. Secondly, Article 20 provides that any person who is convicted of a crime should not receive a penalty greater than what is provided in the law in force at the time of the act of offense. Thirdly, it provides for another important right: no person shall be prosecuted and punished for the same offense more than once. This means that if someone commits an offense, that person should not be harassed and punished repetitively, more than once, for the same offense. Fourthly, it states that no person accused of any offense shall be compelled to be a witness against himself. This provision safeguards the accused's right against self-incrimination. An accused may give information based on own knowledge if he or she chooses to, but cannot be forced to be self-witness against himself or herself. Last, every accused has a right to fair trial. Article 21. Right to life and personal liberty. Article 21 states as follows: no person shall be deprived of his life or personal liberty except according to procedure established by law. This article is most fundamental. It is expansive and covers many other rights and is applicable to both the citizens as well as non-citizens. The meaning of right to life includes right to human dignity, right to basic requirements of life, right to participate in activities and expression, right to tradition, heritage, and culture, and so on. Personal liberty means various rights that provide for personal liberty of a person, i.e., everyone has the right to do as per his or her will freely. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In Unit I. Unit 2. Unit 3. Unit IV. UNITV. 136. Unit V. Unit 7. Unit 8. The second part of the article describes how one's right to life and personal liberty can be taken away. A person can be deprived of his or her right to life or personal liberty only by procedure established by law. This means that any law that limits or takes away one's right to life and personal liberty must contain a procedure that is fair and reasonable and not arbitrary. For example, the Indian Penal Code prescribes death penalty for certain crimes. This involves established procedures like: 1. Death penalty is awarded only in rarest of rare cases, and 2. There should not be a delay in executing the prisoner waiting in death row. Also, Indian Penal Code allows for appeal where the wait period is longer than 5 years. Class activity. Conduct a class debate on whether death penalty should be abolished in India. Article 21A. Right to education. Article 21A states that the state shall provide free and compulsory education to all children of the age of 6 to 14 years in such manner as the state may, by law, determine. This article provides for the right to education to all between the age of 6 and 14 and obligates the state to implement this. Right to life and personal liberty, human dignity, basic necessities of life, engaging in activities and expression, tradition, heritage and culture, privacy, pollution-free environment, livelihood, against sexual harassment, against solitary confinement, legal aid, speedy trial, against delayed execution, in capital punishment, against custodial violence, shelter, healthcare and medical provisions, against bonded labor, against cruel and unusual punishment. The meaning of right to life and personal liberty is broad and embraces many aspects, including, see the table below. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In 137. Unit I. Unit 2. Unit 3, Unit IV, UNITV, Unit V, Unit 7, Unit 8. Prior to 2002, the Indian Constitution considered elementary education for children between age 6 and 14 as a policy goal provision in the Directive Principles of State Policy, which Supreme Court raised to the status of fundamental rights, affirming depriving one from education amounts to depriving one's right to life, Article 21 Fundamental Right. Accordingly, right to education for the children of ages of 6 to 14 is now part of the fundamental rights. Briefly put, directive principles of state policy are not enforceable in a court of law as they are aspirational goals to be achieved over a period of time. In 1992-93, however, the Supreme Court affirmed that depriving one from education amounts to depriving one's right to life under Article 21, which is a fundamental right. This meant that elementary education to the status of fundamental right from that of a policy goal, directive principles, and hence made it enforceable. Accordingly, in 2002, Article 21A providing right to elementary education was created as a fundamental right by the Constitution, 86th Amendment, Act, 2002. The aim is to provide free and compulsory education to all children in the age group of 6 to 14 years in such a manner as the state may, by law, determine. The Right of Children to Free and Compulsory Education, RTE, Act, 2009. The Right of Children to Free and Compulsory Education Act 2009, also known as the RTE Act, was enacted by the Parliament of India in 2009, and it provides that every child has a right to free and compulsory education till completion of elementary education in a neighborhood school. This act places a legal obligation on the state and central governments to implement the fundamental rights of a child in accordance with the provisions of the RTE Act. However, implementing this right requires states' financial and budgetary expenditures of enormous amounts to meet the demand of a high illiteracy rate, which so far has been inadequate. Article 22. Protection against arrest and detention. Article 22 provides safeguards against arrest and detention in following ways. No one can be detained in custody without providing grounds for arrest. The arrested and detained person has a right to consult and to be defended by a legal practitioner of his or her choice. A person who is arrested and detained in custody should be produced before the nearest magistrate within a period of 24 hours. The travel time is not counted towards the 24 hours time frame. No such person can be detained in custody beyond 24 hours without the authority of a magistrate. The above safeguards do not apply to a person from an enemy country to persons arrested or detained under preventive detention laws. Generally, preventive detention laws allow for detaining persons on suspicion who otherwise have not been found guilty of any crime, but their release may be detrimental to society, like they may commit more crimes if released or affect adversely investigations by the state, or they are mentally ill, and so on. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In Unit I, Unit 2, Unit 3, Unit IV, UNITV 138, Unit V, Unit 7, Unit 8. However, Preventive detention laws can be misused, resulting in violations of human rights of the person detained. Detention and arrest. Ordinarily, you may think that being arrested is the same as being detained, but there is a difference between detention and arrest. A person is arrested when he is charged with a crime, whereas if the police have reasonable suspicion against a person that he may have engaged in a crime or may commit crime, they may detain that person for questioning. When a person is detained for questioning, he is not charged with a crime. The main difference between detention and arrest is whether the accused is charged with a crime or not. See, Right Against Exploitation, Articles 23 and 24. Article 23. Prohibition of traffic in human beings and forced labor. Article 23 prohibits human trafficking, beggar and forced labor. Beggar is a Persian word. It is a practice where the worker is forced to give service to the master free of charge or at a nominal remuneration. It is a form of forced labor. Article 24. Prohibition of employment of children in factories, etc. Article 24 prohibits employment of children below the age of 14 years in factories, mining, and other hazardous employment. Human trafficking involves the following: ACT. Recruitment, transport, transfer, harboring, receipt of persons. Plus. Means, threat or use of force, coercion, abduction, fraud, deception, abuse of power, of vulnerability, giving payments or benefits. Plus. Purpose, exploitation including prostitution of others, sexual exploitation, forced labor, slavery or similar practices, removal of organs, other types of exploitations. Trafficking. Top 10 countries infamous for human trafficking. Digital image. Source: www.istnews.com. Other examples of human trafficking: forced labor, forced sex workers, forced organ transplantation, forced surrogacy, forced to work in factories, hazardous activities, forced into begging. Textbook of Legal Studies 12-2023-2024. www.cbcacademic. NIC. In 139. Unit I. Unit 2. Unit 3, Unit IV, UNITV, Unit V, Unit 7, Unit 8. D. Right to freedom of religion, Articles 25 to 28. Article 25. Freedom of conscience and free profession, practice and propagation of religion. Under Article 25, all persons have the right to freedom of conscience, and freedom to profess, practice and propagate religion as long as their acts do not threaten public order, morality and health. For example, on the issue concerning use of loudspeakers for religious purposes, Supreme Court has stated that no religion prescribed that prayers should be performed by disturbing the peace of others, nor does it preach that they should be through voice amplifiers or beating of drums. In the name of religion, nobody can be permitted to add to noise pollution or violate noise pollution norms. Even if there is religious practice to use voice amplifiers, it should not adversely affect rights of others, including that of being nor disturbed in their activities. Noise pollution, regulation and control, rules, 2000 should be followed. Also, the wearing and carrying of kirpans is part of the profession of the Sikh religion and do not threaten public order, morality or health. State may regulate or restrict economic, financial, political or other secular activities that are associated with a religious practice. State can also provide social welfare and reforms in Hindu, Sikh, Jain, or Buddhist religious institutions. State can throw open their religious institutions like temples to all classes and sections of that religious society. Article 26. Freedom to manage religious affairs. Article 26 provides the right to every religious denomination, including their subsect or sects, to establish and maintain institutions for religious and charitable purposes. Manage their own affairs in matters of religion. Own and acquire movable, e.g., vehicles, furniture, and immovable, e.g., house, trees, property. And administer such property in accordance with law. These rights are conditional. They should not endanger public order, morality and health. Article 27. Freedom as to payment of taxes for promotion of any particular religion. Article 27 prohibits forcing anyone to pay any taxes on revenues that are used in payment of expenses for the promotion or maintenance of any religion or sect. For example, donations in temples that are used for the upkeep of the temple cannot be taxed. Article 28. Freedom as to attendance at religious instruction or religious worship in certain educational institutions. Article 28 states that 1. No religious instruction shall be provided in any educational institution wholly maintained out of state funds. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In. Unit I. Unit 2. Unit 3 Unit IV. UNITV. 140. Unit V Unit 7 Unit 8. 2. Nothing in Clause 1 shall apply to an educational institution which is administered by the state but has been established under any endowment or trust which requires that religious instruction shall be imparted in such institution. 3. No person attending any educational institution recognized by the state or receiving aid out of state funds shall be required to take part in any religious instruction that may be imparted in such institution or to attend any religious worship that may be conducted in such institution or in any premises attached thereto unless such person or, if such person is a minor, his guardian has given his consent thereto. Trust is a body registered under the Trust Act, 1882, now 1961, and is run on the basis of no profit no loss. Article 28 prohibits religious instructions in educational institutions that are wholly maintained out of state funds. For example, government-run schools like Sainik schools and Kendriya Vidyalaya schools cannot impart religious instructions to students. However, some educational institutions are exempted from this rule. Those which are administered by the state but are established by endowments or trusts that require religious instruction in such educational institutions. Furthermore, state-recognized or state-aided educational institutions cannot force any student to take part in any religious instruction or to attend any religious worship conducted in such institutions unless she has given consent for the same. In the case of minors, the guardians should have given consent for the same. Wholly funded by state, recognized by state, aided by state, administered by state but established under a trust. Institutions whose entire expenditure is borne by the state government. Institutions that are recognized by the state for imparting instruction or awarding degrees under the state laws. Institutions that are receiving aid out of the state funds. Institutions whose day-to-day administration is in the hands of government. Government educational institutions, for instance, government schools and colleges. Without recognition, the degree of such institutions shall not be recognized for the public employment. Religious instruction cannot be imparted in the educational institutions that are wholly funded by state. Cannot force students to take part in religious instruction, religious worship. In the case of minors, consent of the parent is required. Cannot force students to take part in religious instruction, religious worship. In the case of minors, consent of the parent is required. Institutions that were originally established by a trust which required religious instructions to be imparted, the religious instructions may be imparted in such institution irrespective of the fact that it is administered by the state. These provisions and others make India a secular state. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In 141. Unit I. Unit 2. Unit 3 Unit IV UNITV Unit V Unit 7 Unit 8. A. Cultural and Educational Rights, Articles 29-30. Article 29. Protection of interests of minorities. Article 29 provides minority sections of citizens who have distinct language, script or culture the right to conserve the same. It also prohibits educational institutions, maintained by the state or receiving aid out of state funds, from denying admissions to any citizen on grounds of religion, race, caste, or language. Article 30. Right of minorities to establish and administer educational institutions. Article 30 provides all minorities, whether based on religion or language, the right to establish and administer educational institutions of their choice. It also prohibits state from discriminating educational institutions, while granting them aid, on grounds of religion or language. F. Right to constitutional remedies, Articles 32. Remedies for enforcement of fundamental rights. Article 32 guarantees the aggrieved ones, whose fundamental rights have been violated or denied, to petition directly to the Supreme Court for the enforcement of fundamental rights. Unlike cases of other matters where one has to exhaust remedies of lower courts, in matters of fundamental rights violation one can approach the Supreme Court directly. Similarly, Article 226 authorizes high courts to take up matters of fundamental rights violations directly for their enforcement. Public interest litigation is also known as social action litigation. Article 32 allows for the practice of public interest litigation, which is a process by which even letters written to Supreme Court or High Courts by public-spirited persons or organizations alleging fundamental rights violations are converted into petitions. The author of the letter alleges violations of fundamental rights of the weaker sections of Indian society who are unable to approach the court. They include people in custody, victims of police violence, forced bonded laborers, migrant and contracted laborers, child workers, rickshaw pullers, hawkers, pensioners, pavement dwellers, and slum dwellers. Courts can also act upon newspaper reports alleging fundamental rights violations of victims. 3. Directive Principles, Part 4, Articles 36 to 51. Articles 36 to 51 in Part 4 of the Constitution lays down the guiding principles of governance for the state are called the Directive Principles of State Policy. Given below are few salient features of the Directive Principles. It is the duty of the state to apply these principles in making laws and policies on social and human development. These principles are largely of the nature of economic and social rights. The provisions of directive principles are not enforceable by any court of law, but they provide guidance in carrying out and drafting laws and policies regarding human and social development. The Supreme Court has raised the status of many provisions of directive principles to that of Textbook of Legal Studies 12-2023-2024. www. CBC Academic. NIC. In. Unit I. Unit 2. Unit 3. Unit IV. UNITV. 142. Unit V. Unit 7. Unit 8. Fundamental right by suggesting they violate one's right to life, art. 21. Directive principles aim at promoting the welfare of the people. They intend to secure and protect social, economic, and political justice of its citizens. These principles endeavor to minimize income inequalities and to eliminate inequalities based on status, facilities, and opportunities amongst both individuals and groups of people. Directive principles of policies guide the state to achieve various goals as given in the table below. Directive principles. Right to adequate means of livelihood for both men and women. Equal pay for equal work for both men and women. Right to healthy working conditions for men, women and children. Protection to children against exploitation and against moral and material abandonment. Legal aid for securing justice, for those with economic or other disabilities. Village panchayats vested with powers and functions as units of self-government. Right to work, to education, and to public assistance in cases of unemployment, old age, sickness and disablement, etc. Provision for just and humane conditions of work and for maternity relief. Living wage and conditions of work to agricultural, industrial or other workers that ensures a decent standard of life and full enjoyment of leisure and social and cultural opportunities. Promoting cottage industries on an individual or cooperative basis in rural areas. Participation of workers in management of industries. Uniform civil code for the citizens, one uniform law for family law matters. Provision for early childhood care and education to children below age of 6 years. Promotion of educational and economic interests of scheduled castes, scheduled tribes and other weaker sections and protection from social injustice and all forms of exploitation. raising level of nutrition, standard of living and improving public health and prohibition of the consumption of intoxicating drinks and drugs injurious to health. Organization of agriculture and animal husbandry in a modern and scientific way and preserving and improving the breeds, prohibiting the slaughter of cows. Protection and improvement of the environment and safeguarding of forests and wildlife. Protection of monuments and places and objects of artistic or national importance. Separation of judiciary from executive in the public services of the state. Promotion of international peace and security, maintaining just and honorable relations between nations, fostering respect for international law and treaty obligations, and encouraging settlement of international disputes by arbitration. Textbook of Legal Studies 12-2023-2024. www.cbckademic. NIC. In 143. Unit I. Unit 2. Unit 3 Unit IV UNITV Unit V Unit 7 Unit 8. Supreme Court has raised the status of many provisions of directive principles to that of fundamental rights by suggesting they also violate one's right to life. Art. 21. Directive principle raised to fundamental right is violates one's right to life. Art. 21. Elementary education for children between age 6 and 14 was a policy goal provision. Right to education for children between age 6 and 14 is now a fundamental right under Article 21A. The Supreme Court in the case of Mohini Jain case ruled that right to education is a fundamental right that flows from right to life in Article 21 of the Constitution. Another example is that of right to livelihood, which is a directive principle often read with right to life, as a fundamental right. The Supreme Court has often directed states to rehabilitate slum dwellers whenever they are evicted on grounds of encroachment. Eviction without rehabilitation closer to their workplace amounts to violation of their right to livelihood and in turn the right to life. Livelihood can include basic shelter, food, education, occupation and medical care. The Supreme Court in Olga Tallis and Oz. V. Bombay Municipal Corporation and Oz. Popularly known as the Pavement Dwellers case, held that right to livelihood is born out of right to life, as no person can live without means of living, that is, means of livelihood. It recognized right to livelihood to be part of Article 21. The court also held that it is the duty of the authorities to provide slum dwellers with an alternative if their house is to be demolished. 4. Fundamental Duties Part 4a, Article 51a Part 4a, Article 51a of the Constitution prescribes fundamental duties of every citizen. In that, certain conduct and behavior are expected of the citizens. The salient features of fundamental duties are given below. The fundamental duties cannot be enforced in a court of law for violation of the duties, and no one can be punished for violation. Fundamental duties contain standards to be followed by the citizens. They remind citizens not to behave irresponsibly but help build a free, democratic and strong society. It may be possible that, just like some provisions of the directive principles, courts may raise the status of these duties in future. Fundamental duties. Respecting the Constitution and institutions, the national flag and the national anthem. Cherishing and following the noble ideals of the national struggle for freedom. Upholding and protecting the sovereignty, unity, and integrity of India. Defending the country and rendering national service when called upon to do so. Textbook of Legal Studies 12-2023-2024. www.cbckademic. NIC. In. Unit I. Unit 2. Unit 3 Unit IV. UNITV. 144. Unit V Unit 7 Unit 8. Promoting harmony amongst religious, linguistic and regional diversities and renouncing practices derogatory to women's dignity. Valuing and preserving the rich heritage and culture. Protecting the natural environment including forests, lakes, rivers and wildlife. Developing the scientific temper, humanism and the spirit of inquiry and reform. Safeguarding public property and abjuring violence. striving for excellence and raising the nation to higher levels of endeavor and achievement. Providing opportunities for education to children by their parents between the age of 6 and 14 years. Class activities. Activity 1. There are different ways in which one can see or understand human rights. Write your views in 200 words on any one of the following. Are human rights anti-majoritarian, protection of minorities from the domination of the majority? Are human rights a moral demand to resolve various kinds of injustices? Are human rights a tool for sloganeering and disruptions? Activity 2. Watch this 2016 award-winning video on human rights from India by Anuj Ramchandran. Web links. How after watching this video made you sensitive towards human rights? After watching this video, write in 100 words how it has made you sensitive towards human rights. Activity 3. Go to the website of UN High Commissioner for Human Rights. Write a review of the site. You may include following points in the review. What is it that you found interesting about the site? What content on the site surprised you? What information was useful to you? Was there any idea or information that was missing that you want to be included on the site? Textbook of Legal Studies 12-2023-2024. www.cbcacademic. NIC. In 145. Unit I. Unit 2. Unit 3. Unit IV. UNITV. Unit V. Unit 7. Unit 8. Exercise. Based on your understanding, answer the following questions. 1. Human rights and SDGs are two sides of the same coin. Explain. 2. Explain states' obligations to respect, protect and fulfill human rights. 3. Identify any two features in the preamble of the Indian Constitution that indicates its objective of protecting human rights. 4. Describe any three salient features of fundamental rights in the Indian Constitution. 5. What is right to equality? How is reservation or affirmative action for government jobs to scheduled castes and scheduled tribes protected by the right to equality? 6. Why do you think it was necessary to abolish the practice of untouchability? 7. Identify any two kinds of right to freedoms along with any two grounds of restrictions that take away these freedoms. 8. Explain any one fundamental right of a person who is either accused or convicted of a crime. 9. Explain right to life and personal liberty, as given in the Indian Constitution. 10. Explain right to education, provided in the Fundamental Rights chapter of the Constitution. 11. Identify any one safeguard provided to someone if he is arrested and detained. 12. What is meant by human trafficking, that is prohibited by the Indian Constitution. 13. Describe right to freedom of religion, as provided in the Indian Constitution. 14. Explain judicial remedies that are available for the enforcement of fundamental rights. 15. What is meant by public interest litigation, PIL? Find out one PIL that was initiated on the basis of a letter written to the Supreme Court or on the basis of a newspaper report. 16. Describe any one salient feature of the directive principles of state policy. Give one example of directive principle that has been elevated to fundamental rights. 17. Give any one example of fundamental duties provided in the Constitution. Bibliography 1. Clapham, Andrew. Human Rights, a very short introduction. Oxford. Oxford UP, 2007. Print. 2. Gandhi, Ankita. India Human Development Report, 2011, Towards Social Inclusion. New Delhi, Institute of Applied Manpower Research, Planning Commission, Government of India, 2011. Print. 3. Handbook of Human Rights and Criminal Justice in India. New Delhi, Oxford UP, 2010. Print. 4. How We Make a Difference. OHCHR News. Web. 5. Human Rights, United Nations, UN, Genocide, Children, Women, Violence, Indigenous, Holocaust, Rwanda, Africa, Disability. UN News Center. UN. Web 6. Human Trafficking. Digital image. www.anadc.org. Web. 7. International Human Rights Law. www.ohchr.org. Office of the High Commissioner for Human Rights. Web. Textbook of Legal Studies 12-2023-2024. www.cbckademic. NIC. In. Unit I. Unit 2. Unit 3. Unit IV. UNITV. 146. Unit V. Unit 7. Unit 8. 8. Introducing Human Rights. An overview including issues of gender justice, environmental, and consumer law. New Delhi, Oxford UP, 2006. Print. 9. Kothari, Jaina. The Future of Disability Law in India. A critical analysis of the persons with disabilities, equal opportunities, protection of rights and full participation, Act 1995. New Delhi, Oxford UP, 2012. Print. 10. Mangubhai, Jayashree P. Human Rights as Practice, Dalit Women Securing Livelihood Entitlements in South India. New Delhi, Oxford UP, 2014. Print. Textbook of Legal Studies 12-2023-2024. www.cbckademic. NIC. In 147. Unit I. Unit 2. Unit 3. Unit IV. UNITV. Unit V. Unit 7. Unit 8. Human Rights Violations, Complaint Mechanism, Quasi-Judicial Bodies. Learning Outcomes. Students will be able to name the various human rights commissions in India, identify the functions and powers of various human rights commissions in India, discuss the complaint mechanism of these human rights commissions. The focus of this chapter is on the human rights commissions and their complaint mechanisms. A. What are quasi-judicial bodies? The quasi-judicial bodies typically are public administrative agencies under the realm of the executive branch and are largely bestowed with authority similar to courts. These bodies have the power to resolve disputes and also impose punishments. Examples of quasi-judicial institutions include national and state human rights commissions, central and state information commissions, consumer redressal forums and commissions, income tax tribunals, and so on. The most fundamental human rights bodies are the national human rights institutions that include the following: National Human Rights Commission, NHRC, National Commission for Minorities, National Commission for Women, NCW, National Commission for Scheduled Castes, National Commission for Scheduled Tribes, and National Commission for Protection of Child Rights, NCPCR. These commissions are independent or autonomous and transparent bodies that are created under specific legislations to promote and protect human rights. For example, the National and State Human Rights Commissions are governed by the Protection of Human Rights Act, 1993. National commissions have jurisdiction over the entire nation, whereas the parallel state commissions take matters of human rights violations from the respective states. Chapter 5, B, Textbook of Legal Studies 12-2023-2024. www.cbckademic. NIC. In. Unit I. Unit 2. Unit 3. Unit IV. UNITV. 148. Unit V. Unit 7. Unit 8. B. Various Human Rights Commissions 1. National Human Rights Commission, NHRC, 1.1 Introduction. The specific legislation called the Protection of Human Rights Act was enacted by the Parliament in 1993, which in turn established the National Human Rights Commission as an independent institution with powers and functions to promote and protect human rights. This act also provides for the constitution of state human rights commissions at state levels for access to complaint mechanisms at the state level. 1.2 Constitution. The National Commission is headed by the chairperson, who is a former Chief Justice of the Supreme Court. The other members of Commission are: one member who is a former judge of the Supreme Court, another member who is present or former Chief Justice of a High Court, and two other members with knowledge or experience in matters relating to human rights. Besides, There is a Secretary General who is the Chief Executive Officer of the Commission who largely discharges administrative duties of the Commission. The chairperson and the members are appointed by the President of India on recommendation of a committee consisting of the Prime Minister, the Speaker of the House of the People, Lok Sabha, Minister of Home Affairs at the Centre, Leader of Opposition in the Lok Sabha, Leader of Opposition in the Council of States, Rajya Sabha, and Deputy Chairman of the Rajya Sabha. The committee is required to consult the Chief Justice of India whenever a sitting judge of the Supreme Court or sitting Chief Justice of a High Court is appointed to the commission. The government also appoints police officers and investigative staff and other administrative, technical and scientific personnel for the efficient functioning of the commission. The National Commission is based in New Delhi. The state commissions also complement the working of the National Commission. 1.3 Functions of the Commission. The Commission is vested with the functions as given below. Inquiry and investigation. One of the Commission's roles is to conduct inquiry and investigation into the alleged violation of human rights or abetment, aiding or supporting, or negligence in the prevention of such violation by a public servant. The complaint can be filed by the victim or his or her representative, or the court may direct the Commission with a complaint, and at times the Commission may initiate inquiry and investigation on its own, suo motu. Suo motu means, on its own motion, and relates to an action taken by a court of its own accord, without any request by the parties involved. For example, the Commission may inquire suo motu based on some human rights violations news or report published through the media. Textbook of Legal Studies 12-2023-2024. www.cbckdemic. NIC. In 149. Unit I. Unit 2. Unit 3 Unit IV UNITV Unit V Unit 7 Unit 8. Suo motu inquiry is especially useful when the victims belong to weaker sections of the society and have limited access to justice delivery mechanisms. 1.4 Powers of the Commission. The Commission has the powers of a civil court. In conducting an inquiry or investigation, the Commission can utilize various powers including the following: summon and enforce the attendance of witnesses and examine them on oath. Ask for production of any document before itself. Receive evidence on affidavits. Request public record from any court or office. And examine witnesses or documents. On completion of inquiry. Once the inquiry is completed, the Commission can make recommendations to governmental authority in cases where any public servant is the perpetrator of human rights violation. The recommendation may include payment of compensation to the victims or suggest initiation of proceedings for prosecution of the public servant. The Commission can also approach the Supreme Court or the High Court for directions and orders. The Commission may also ask the state authority to provide immediate interim relief to the victim. Intervening in court proceedings. The Commission may, with the permission of the court, intervene in court proceedings concerning human rights violations. For example, the Commission can request the Supreme Court to transfer pending riot cases out of a state in which the riots had happened to ensure the witnesses are not threatened in any manner and that evidences are not damaged. Inspection of jails, etc. The Commission may also visit any jail or other governmental institutions, where prisoners are lodged or detained, to study the living conditions of the inmates and make recommendations to the government. Awareness and sensitization. The Commission can review various human rights laws either in the Constitution or other statutes and recommend measures to the government for their effective implementation. The Commission can also evaluate various factors, including acts of terrorism, which prevent the enjoyment of human rights and recommend appropriate remedial measures to the government. The Commission's role includes studying various international human rights laws and make recommendations for their effective implementation at the domestic level, within the state. Furthermore, the Commission can undertake and promote research in the field of human rights as well as spread human rights literacy among various sections of society. It can promote awareness of the safeguards available for the protection of human rights through publications, media, seminars, and other available means. Textbook of Legal Studies 12-2023-2024. www. CBCKdemic. NIC. In. Unit I. Unit 2. Unit 3. Unit IV. UNITV. 150. Unit V. Unit 7. Unit 8. Lastly, the Commission can encourage and support the efforts of non-governmental organizations and institutions involved with human rights work. 1.5 Complaint Mechanism. The complaint mechanism procedure with the National Human Rights Commission is easy and straightforward. Anyone aggrieved of human rights violation or their representatives can lodge a complaint with the Commission in any language. The complaint can be filed online at www.nhrc.nic.in or by paper petition using the complaint format provided on the website. The complaint can be sent either by post or fax or through email. There is no fee for filing a complaint. The complaint must be filed within a year of the occurrence of the human rights violation. Once the complaint is pending before the Commission, one can check the status of the complaint online. In class exercise, National Human Rights Commission of India has prescribed a complaint format as given below. Use the format and prepare a complaint on any human rights violation, either hypothetical or real, that you may be aware of, or you may have read, heard in the news, and so on. The NHRC guidelines given below in row 3 are for reference purpose. This complaint must be used for classroom exercise only and be submitted to the course instructor for evaluation. Format for filing a complaint with the NHRCA. Complainant's details: 1. Name. 2. Sex. Male, female. 3. State. 4. Full address. 5. District. 6. PIN code. B. Incident details: 1. Incident place, village, town, city. 2. State. 3. District. 4. Date of incident. C. Victim's details. 1. Name of the victim. 2. No. Of victims. 3. State. 4. Full address. 5. District. 6. PIN code. 7. Religion. Textbook of Legal Studies 12-2023-2024. www.cbckdemic. NIC. In 151. Unit I. Unit 2. Unit 3. Unit IV. UNITV. Unit V. Unit 7. Unit 8. 8. Caste, SC, ST, OBC, General, 9. Sex. 10. Age. 11. Whether disabled person, D. Brief summary of facts, allegations of human rights involved, E. Whether complaint is against members of armed forces, paramilitary, yes, no, F. Whether similar complaint has been filed before any court, State Human Rights Commission, G. Name, designation and address of the public servant against whom complaint is being made, H. Name, designation and address of the authority, officials to whom the public servant is answerable, I. Prayer, relief if any, sought. Guidelines on how to file complaint with the NHRC. 1. Complaint may be made to the Commission by the victim or any other person on his behalf. 2. Complaint should be in writing either in English or Hindi or in any other language included in the 8th schedule of the Constitution. Only one set of complaint needs to be submitted to the Commission. 3. Complaint may be sent either by post or fax or email. 4. No fee is chargeable on such complaints. 5. The complaint shall disclose, I. Violation of human rights or abatement thereof. Or, E. Negligence in the prevention of such violations, by a public servant. 6. The jurisdiction of the Commission is restricted to the violation of human rights alleged to have been committed within 1 year of the receipt of complaint by the Commission. 7. Documents, if any enclosed in support of the allegations in the complaint, must be legible. 8. Name of the victim, his, her age, sex, religion, caste, state and district to which the incident relates, incident date, etc. should invariably be mentioned in the complaint. 9. Please submit the complaint preferably in the enclosed format. 10. Following types of complaints are not ordinarily entertainable. I. Illegible. E. Vague, anonymous or pseudonymous. E. Trivial or frivolous in nature. IV. The matters which are pending before a state human rights commission or any other commission. V. Any matter after the expiry of 1 year from the date on which the act constituting violation of human rights is alleged to have been committed. V. Allegation is not against any public servant. V. The issue raised relates to civil dispute, such property rights, contractual obligations, etc. V. The issue raised relates to service matters. X. The issue raised relates to labor, industrial disputes. X. Allegations do not make out any specific violation of human rights. Xi. The matter is sub judice before a court tribunal. Xi. The matter is covered by judicial verdict, decision of the commission. As far as possible, complainants are encouraged to make use of the format given above to file their complaints. The guidelines indicate the kind of information which would facilitate in processing a complaint. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In. Unit I. Unit 2. Unit 3. Unit IV. UNITV. 152. Unit V. Unit 7. Unit 8. 2. National Commission for Minorities. 2.1 Introduction. National Commission for Minorities Act, 1992 was enacted by the Parliament to create the National Commission for Minorities to safeguard the human rights of minorities, including protection against inequality and discrimination. Minorities' human rights are enshrined in the Constitution as well as other laws enacted by Parliament and the state legislatures. The minorities here are referred to religious minorities of Muslims, Christians, Sikhs, Buddhists, Jains and Zoroastrians, Parsis. Many states also have instituted the State Minorities Commissions and are located in the respective state capitals. Persons who belong to the minority communities can approach the state as well as National Minorities Commission for remedying human rights violations. 2.2 Constitution. The National Minorities Commission consists of a chairperson, a vice-chairperson and 5 other members who are nominated by the central government from amongst the minority communities who are persons of eminence, ability and integrity. 2.3 Functions of the Commission. The functions of the Commission include the following: evaluating the progress of the development of minorities. Monitoring the working of the safeguards provided in the Constitution and in other laws enacted by Parliament and the state legislatures. Making recommendations for the effective implementation of safeguards for the protection of the interests of minorities by the central government or the state governments. Looking into specific complaints regarding deprivation of rights and safeguards of the minorities and taking up such matters with the appropriate authorities. Initiating studies on problems arising out of any discrimination against minorities and recommending measures for their removal. Conducting studies, research, and analysis on the issues relating to socio-economic and educational development of minorities. Suggesting appropriate measures in respect of any minority to be undertaken by the central government or the state governments. And making periodical or special reports to the central government on any matter pertaining to minorities and in particular the difficulties confronted by them. 2.4 Powers. Like the National Human Rights Commission, the National Commission for Minorities is vested with powers of a civil court. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In 153. Unit I. Unit 2. Unit 3. Unit IV. UNITV. Unit V. Unit 7. Unit 8. When the Commission tries any suit or hears a complaint, it has the powers to 1. Summon and enforce the attendance of any person and examine him or her on oath. 2. Require the discovery and production of any document. 3. Receive evidence of affidavits. 4. Request any public record or copy from any court or office. And 5. Issue commissions for the examination of witnesses and documents. 2.5 Complaint Mechanism. There are many grounds on which the Commission typically declines admitting the complaint. Firstly, it does not entertain or admit cases or complaints that do not relate to minority status or rights. Secondly, the complaint should not be pending before another court or commission, i.e., matters that are sub judice. Sub judice in Latin stands for under a judge. It means that a particular case or matter is under trial or being considered by a judge or court. Thirdly, where the complainant has not availed of other ordinary judicial, quasi-judicial, administrative institutions that are available for redressal, the Commission does not admit such matters unless the complainant has reasonable justification. Fourthly, the complaint should not relate to events that are more than 1 year old. Fifthly, complaint should not be vague, anonymous, pseudonymous, or frivolous. Lastly, Commission does not entertain complaints that are not directly addressed to it. Like the NHRC, the National Commission for Minorities can also take action suo motu based on newspaper reports or other findings. Applications of complaints are required to be sent to the Commission and addressed directly to the Secretary, National Commission for Minorities, New Delhi. It does not charge any fee for lodging a complaint. The updated contact details are available on the Commission's website at www.ncm.nic. In 3. National Commission for Women, NCW. 3.1 Introduction. In 1992, the National Commission for Women was established under the National Commission for Women Act, 1990. 3.2 Constitution. The Commission consists of a chairperson and 5 members who are nominated by the central government from amongst persons of ability, integrity, and standing who have had experience in Textbook of Legal Studies 12-2023-2024. www.cbckademic. NIC. In Unit I, Unit 2, Unit 3, Unit IV, UNITV 154, Unit V, Unit 7, Unit 8. Any one of these areas law or legislation, trade unionism, management of an industry, potential of women, women's voluntary organizations, including women activists, administration, economic development, health, education, or social welfare. At least one member each belongs to the scheduled castes and scheduled tribes communities. The member secretary takes care of the administrative matters. 3.3 Functions. The Commission has been charged with the following functions: to investigate and examine matters relating to the safeguards provided for women under the Constitution and other laws. To present annual and other reports to the central government about the working of the safeguards. To make recommendations to central and states for the effective implementation of safeguards for improving the conditions of women. To review provisions of the Constitution and other laws affecting women and make recommendations about remedial legislative measures required to address inadequacies or shortcomings in the laws. To take up cases with the appropriate authorities about violation of women human rights as provided in the Constitution and other laws. To look into complaints and also take suo motu notice of matters on deprivation of women's rights. Non-implementation of laws required to achieve equality in development. And non-compliance of policy decisions, guidelines or instructions pertaining to women welfare. To initiate special studies or investigations into specific problems or situations arising out of discrimination and atrocities against women and to identify the constraints and to recommend strategies. To undertake promotional and educational research and to suggest ways for ensuring due representation of women in all spheres and to identify factors responsible for impeding women's advancement, such as lack of access to housing and basic services, inadequate support services and technologies for reducing drudgery and occupational health hazards, and for increasing their productivity. To participate and advise on the planning process of socio-economic development of women. To evaluate the progress of the development of women under the Union and any state. To inspect a jail, remand home, women's institution, or other place of custody where women are kept as prisoners or otherwise and take up with the concerned authorities for remedial action, if found necessary. To fund litigation involving issues affecting a large body of women. And to make periodical reports to the government on any matter pertaining to women and in particular various difficulties under which women toil. 3.4 Powers. The Commission has investigating powers similar to that of a civil court. In that, the Commission can do the following: Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In 155. Unit I. Unit 2. Unit 3, Unit IV, UNITV, Unit V, Unit 7, Unit 8. Summon and enforce the attendance of any person and examining him or her on oath. Require the discovery and production of any document. Receive evidence on affidavits. Request any public record or copy from any court or office. And issue commissions for the examination of witnesses and documents. Class activity. Go to www.ncw.nic. In write a report about the working of National Commission for Women. Examine the role of NCW in eradicating social evils against women and steps it has taken towards women empowerment. 4. National Commission for Scheduled Castes and Scheduled Tribes. 4.1 Introduction. Article 338 of the Constitution of India provides for establishing a special officer for the scheduled castes and scheduled tribes to investigate all matters relating to the safeguards provided for the scheduled castes and scheduled tribes in the Constitution and report to the President. The two commissions instituted in fulfillment under Article 338 are the National Commission for Scheduled Castes and the National Commission for Scheduled Tribes. These are instituted to protect the human rights of scheduled castes and scheduled tribes, prevent their exploitation, and to encourage and defend their social, educational, economic, and cultural securities as provided in the Constitution and other legislations. For example, state provides reservation or affirmative action programs for government jobs to backward classes like scheduled castes and scheduled tribes who, because of historical and continued disadvantages based on caste status and otherwise, have not been adequately represented in the services under the state. Examples of special laws for protection of minorities include the Protection of Civil Rights Act, 1955, and Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act, 1989. 4.2 Functions. Both commissions have similar powers and functions as provided in Art. 338 to investigate and monitor all matters relating the safeguards provided for the scheduled castes and scheduled tribes in the Constitution and other laws. To evaluate the working of the safeguards. To inquire into specific complaints with respect to the deprivation of rights and safeguards of the scheduled castes and scheduled tribes. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In Unit I, Unit 2, Unit 3, Unit IV, UNITV 156, Unit V, Unit 7, Unit 8. To participate and advise on the planning process of socio-economic development of the scheduled castes and scheduled tribes and to evaluate the progress of their development under the Union and any state. To present to the President, annually and periodically, reports on the working of the safeguards and recommendations for the effective implementation of the safeguards and protection, as well as welfare and socio-economic development of the scheduled castes and scheduled tribes. 4.3 Powers. Just like the other human rights commissions, the two commissions for scheduled castes and scheduled tribes have the powers of a civil court in trying a suit, and commissions can do the following: summon and enforcing the attendance of any person from any part of India and examining him on oath. Require the discovery and production of any document. Receive evidence on affidavits. Request any public record or copy from any court or office. And issue commissions for the examination of witnesses and documents. Art. 338 also mandates the Union and every state governments to consult the commissions on all major policy matters affecting scheduled castes and scheduled tribes. 4.4 Complaint Mechanism. The commissions receive complaints from an individual or group of persons alleging denial of the safeguards provided in the Constitution by an authority or an organization. The commissions follow up with the authorities and organizations against whom the complaint is lodged. The websites of the commissions are www.ncsc.nic. In for the scheduled castes and www.ncsc.nic. in for the Scheduled Tribes. 5. National Commission for Protection of Child Rights, NCPCR. 5.1 Introduction. The National Commission for Protection of Child Rights is an Indian statutory body established by an Act of Parliament, the Commission for Protection of Child Rights Act, 2005. The National Commission for Protection of Child Rights, NCPCR, emphasizes the principle of universality and inviolability of child rights and recognizes the tone of urgency in all the child-related policies of the country. For the Commission, protection of all children in the 0 to 18 years age group is of equal importance. Thus, policies define priority actions for the most vulnerable children. This includes focus on regions that are backward or on communities or children under certain circumstances, and so on. NCPCR logo, Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In 157. Unit I. Unit 2. Unit 3 Unit IV UNITV Unit V Unit 7 Unit 8. The NCPCR believes that while in addressing only some children, there could be a fallacy of exclusion of many vulnerable children who may not fall under the defined or targeted categories. In its translation into practice, the task of reaching out to all children gets compromised and a societal tolerance of violation of child rights continues. This would in fact have an impact on the program for the targeted population as well. Therefore, it considers that it is only in building a larger atmosphere in favor of protection of children's rights, that children who are targeted become visible and gain confidence to access their entitlements. For the Commission, every right the child enjoys is seen as mutually reinforcing and interdependent. Therefore, the issue of gradation of rights does not arise. A child enjoying all her rights at her 18th year is dependent on the access to all her entitlements from the time she is born. Thus, policies' interventions assume significance at all stages. For the Commission, all the rights of children are of equal importance. 5.2 Functions. The functions of the National Commission for Protection of Child Rights are laid out in the Commission for Protection of Child Rights, CPCR, Act, 2005. The Commission shall perform all or any of the following functions. 1. Examine and review the safeguards provided by or under any law for the time being in force for the protection of child rights and recommend measures for their effective implementation. 2. Present to be central government, annually and at such other intervals, as the Commission may deem fit, reports upon working of those safeguards. 3. Inquire into violation of child rights and recommend initiation of proceedings in such cases. 4. Examine all factors that inhibit the enjoyment of rights of children affected by terrorism, communal violence, riots, natural disaster, domestic violence, HIV/AIDS, trafficking, maltreatment, torture and exploitation, pornography and prostitution and recommend appropriate remedial measures. 5. Look into the matters relating to the children in need of special care and protection, including children in distress, marginalized and disadvantaged children, children in conflict with law, juveniles, children without family and children of prisoners and recommend appropriate remedial measures. 6. Study treaties and other international instruments and undertake periodical review of existing policies, programs and other activities on child rights and make recommendations for their effective implementation in the best interest of children. 7. Undertake and promote research in the field of child rights. 8. Spread child rights literacy among various sections of society and promote awareness of the safeguards available for protection of these rights through publications, the media, seminar and other available means. 9. Inspect or cause to be inspected any juvenile's custodial home, or any other place of residence or institution meant for children, under the control of the central government or any state government or any other authority, including any institution run by a social organization, where children are detained or lodged for the purpose of treatment, reformation or protection, and take up with these authorities for remedial action, if found necessary. 10. Analyze existing law, policy and practice to assess compliance with Convention on the Rights of the Child, undertake inquiries and produce reports on any aspects of policy or practice affecting. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In. Unit I. Unit 2. Unit 3. Unit IV. UNITV. 158. Unit V. Unit 7. Unit 8. Children and comment on proposed new legislation related to child rights. 11. Present to the central government annually and at such other intervals as the Commission may deem fit, reports upon the working of those safeguards. 12. Undertake formal investigation where concern has been expressed either by children themselves or by a concerned person on their behalf. 13. Promote respect and serious consideration of the views of children in its work and in that of all government departments and organizations dealing with child. 14. Produce and disseminate information about child rights. 15. Compile and analyze data on children. 16. Promote the incorporation of child rights into the school curriculum, training of teachers or personnel dealing with children. 5.3 Powers. Inquire into complaints and take suo motu notice of matters related to 1. Deprivation and violation of child rights. 2. Non-implementation of laws providing for protection and development of children. 3. Non-compliance of policy decisions, guidelines or instructions aimed at mitigating hardships to and ensuring welfare of the children and to provide relief to such children or take up the issues arising out of such matters with appropriate authorities. Such other functions as it may consider necessary for the promotion of child rights and any other matter incidental to the above functions. The Commission shall not inquire into any matter which is pending before a State Commission or any other Commission duly constituted under any law for the time being in force. 5.4 Complaint Mechanism. One of the core mandates of the Commission is to inquire into complaints of violations of child rights. The Commission is also required to take suo motu cognizance of serious cases of violation of child rights and to examine factors that inhibit the enjoyment of rights of children. Complaints may be made to the Commission in any language listed in the 8th schedule of the Constitution. A. No fee shall be chargeable on such complaints. B. The complaint shall disclose a complete picture of the matter leading to the complaint. C. The Commission may seek further information, affidavit as may be considered necessary. While making a complaint, please ensure that the complaint is clear and legible, not vague, anonymous or pseudonymous. Genuine, not trivial or frivolous. Not related to civil disputes such as property rights, contractual obligations and the like. Not related to service matters. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In 159. Unit I. Unit 2. Unit 3. Unit IV. UNITV. Unit V. Unit 7. Unit 8. Not pending before any other commission duly constituted under the law or sub judice before a court, tribunal. Not already decided by the Commission. Not outside the purview of the Commission on any other grounds. Complaints may be addressed to National Commission for Protection of Child Rights, 5th floor, Chandalik Building, 36 Janpath, New Delhi 11001. Phone 011-234-7820. Fax 011-23724-026. For complaint, www. Ebalnedan. NIC. In. Source. Web links. Exercise. Based on your understanding, answer the following questions. 1. Explain any one power or function of the National Human Rights Commission. 2. Who are minorities whose interest the National Commission for Minorities intends to protect? 3. Ms. Bagchi is a Jewish woman who has married outside her community, because of which she is disallowed to perform certain religious customs. What could be the grounds of disqualification of her complaint to the National Commission for Minorities? 4. Ms. Nisha Joseph is a Christian and her services were terminated by a school managed by state-run non-governmental organization without any substantial reasons. What is the remedy available to her for redressal of this issue? 5. SMT. Savitri is troubled by the exploitation that is being faced by her deaf and dumb daughter who has been abandoned by her husband and in-laws, allegedly due to her disabilities. Which forum can she approach for redressal of issues being faced by her? State its powers and functions. 6. Why were the National Commission for Scheduled Castes and the National Commission for Scheduled Tribes created? 7. Ravi avails benefits of being a member of scheduled caste in his service under the central government. In a matter of promotion with his department, he moved to the Central Administrative Tribunal. As the matter is pending for a long time, he decides to obtain a speedier redressal of his cause and moves to the National Commission for Scheduled Castes. Decide if the matter will be entertained by the Commission. Also set out the various grounds on which the Commission can reject a complaint made to it. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In. Unit I. Unit 2. Unit 3. Unit IV. UNITV. 160. Unit V. Unit 7. Unit 8. Bibliography. 1. National Commission for Scheduled Castes, Government of India. Home National Commission for Scheduled Castes. Web. 2. National Commission for Scheduled Tribes, NCST. National Commission for Scheduled Tribes, NCST. NP. ND. Web. The 21st of August. 2014. 3. National Commission for Women, New Delhi, India. National Commission for Women, New Delhi, India. Web. 4. National Human Rights Commission, New Delhi, India. National Human Rights Commission, New Delhi, India. Web. 5. National Human Rights Commission, New Delhi, India. National Human Rights Commission, New Delhi, India. Web. 6. India. National Commission for Women. www. NCW. NIC. In. Web. Unit 6. International Law. Textbook of Legal Studies 12.